Recording? Okay, ciao everyone. I hope you've had your coffee and you're ready to sit in for this nice long presentation by Brian Barcelona of Limestone Management for your required by law, Florida law, uh, Condominium Board Certification. So right off the bat, I just want to remind anyone, if you're here for an HOA or a Homeowners Association certification, you will not be certified by this class. So Brian will tell you more about that. But it is Memorial Weekend. I would like to say or read a quote that I found that moved me and hope you appreciate it too. It was very simple. It said, all gave some and some gave all. Remember them this Memorial Day. And it's also in the Bible that says, greater love has no one than to lay down one's life for one's friends. So we should never forget, of course, and we are free because of their ultimate sacrifice, and we will be forever grateful. I want to go on and get started with some housekeeping. First of all, you have to stay on 4 hours for this course to get credit. Your emails and phone calls are being recorded. We're logging in the time because this is required by the DBPR. There are no CEU credits given today for any cams that are on. Of course, you can listen and stay on, but there will be no CEU credits posted. If you have a question, go to the Q&A box. Please post it in Q&A, not the chat box. We are recording the Q&A box only. You can make a comment, certainly, and that's not a problem. And you might see the sponsors entering their information about their companies into the chat box for everyone to see. Brian is going to allow us to receive slides. All of his slides will be distributed, and this is being recorded. So I will send out the recording link, the slides, and the sponsor sheet of everyone who's sponsored today if you want to reach out to them. So with that said, let's get into hearing from our sponsors. They have a couple of things to say about theirself and their company. I'm going to start with Vinteum Software. Today we have Julia Alvarez and we have Amanda, who is the national or international marketing manager for Vinteum. Tell us about the company, Amanda, and yourself. What are you doing for associations?
Great. Good morning, everyone. Well, we know how community management can feel like a full-time job, right? That's why we created Neighbors by Vinteum over 10 years ago. It's an all-in-one app and portal that helps board members from finances to amenity reservations to multi-channel communication. Imagine updating residents across SMS, email, smart calls, and more, even in emergencies, all from one place. So if your community wants to enjoy this all-in-one app benefits, we'll drop a link for you to schedule a free demo and to see Neighbors in action. Thank you very much.
Okay, thank you, Amanda. So one thing I also like to mention for them is that in Florida, if you have 25 units or more in your condominium, you are required by law to have a website. So give them a shot, take a look at them. If you want to update your website or consider a change, they are all up to date with even electronic voting and so on. So their name, Amanda, will be on the sponsor sheet. Next, I want to introduce today's moderator. We have Jamie Gelfand. She's with First Citizens Bank. Jamie, tell us about yourself and what you do.
Hi, good afternoon, everybody. My name is Jamie Gelfand. I'm the Regional Sales Officer at First Citizens Bank. First Citizens is a 125-year-old top 20 bank. I work in the CAB Community Association Banking Division, where we service management companies and self-managed association to provide them their banking needs through accounts, loans, reserves, FDIC protection, etc. I will be moderating the class today, so if you would just put your questions into the Q&A so that I can respond to them. Thank you.
Okay, great, awesome. Okay, next I want to introduce Munyon Contractors. Today we have Ashley Leonardo on. Ashley, tell us about yourself and what does Munyon do for the state? You're all over.
Hey, yeah, thanks, Peggy. I know you also mentioned Memorial Day, and we do have a lot of veterans on our staff, so that's something that, we're very proud of, and that we kind of like to represent and honor them, and their sacrifices that they've made. So for those of you who don't know us, Munyon Painting is Florida's top choice painting contractor, and we handle all apartment, condo, HOA, commercial, residential, you name it, we can paint it. And that's interior or exterior painting needs down to a door, a railing, stuff like that. And we've been in business for over 74 years. So that's since 1951. And we do cover the entire state of Florida. So I'm over here on the West Coast, but we have teams all across the state. So, Orlando, Clearwater, Fort Myers, Miami, all the way to the northern border, all the way down to the southern Keys. So we also have a client care center implemented into our website. So that lets you guys access live updates on your property if you're a client of ours. So any board members, residents, anybody that's kind of, asking for updates and kind of looking for photos, stuff like that, they can access that all on the website. So if you guys have any painting or GC needs, I'll put my info in the chat there, and yeah, look forward to another one. Thanks, guys.
Okay, very good. One thing that was mentioned in a webinar before I was very impressed with is that they do electrostatic painting on the railings. You want to say a little bit about that?
Now, I myself don't have too much experience in our electrostatic. I know Shelly, who operates in our East Coast, probably knows a lot more. But I also know that we have a wealth of information on our website about that. And I have some great literature too. But yeah, we do electrostatic. We'll roll paint. We do, the roofs, everything, or like painting on the roofs, the TPO, stuff like that. So anything you guys need in that regard, yeah, we have a big in-house crew for you.
Okay, great.
Thanks,
All
Peggy.
right, next I want to, let's see, he's not on yet. Let's go with Bob Aleka. Bob, from Faster IO, please introduce yourself and tell us what you guys are doing.
Well, good morning, all. Thanks, Peggy. It's Bob Aleka here with Faster IO. Faster IO has been for the last 20 years building, managing, maintaining, and providing internet through fiber optics to condominiums, HOAs, businesses, so forth and so on, especially for all the other service providers. So today we now are providing the same service to condominiums and HOAs directly through us, including streaming TV. The streaming TV allows you to take it with you, even if you leave the country. We provide a VPN for every resident, so they have a secure connection, whether they're doing just banking or just surfing the web. But if they leave the country, the VPN allows them to watch their TV anywhere they go. In addition, if you are a snowbird and you leave your property and go home to wherever you live, you can change your address and you'll get everything at home, including the locals of your zip code. So if you're in a bulk agreement or you just have a retail right now and you're, say, 15 units or more, and you're looking for just another addition to see what you have out there, please give me a call. I'll leave my information in the chat and look forward to speaking with you. Thanks and enjoy the class.
Hey, Bob, thank you so much. Next, I want to introduce Mustafa Adib. He's with PD Concrete. Please tell us about yourself and what you guys are doing over there.
Yes, thank you, Peggy. Good morning. My name is Mustafa Adib. I'm the project manager with PD Concrete Specialist. We are specialized in concrete restoration, structural repairs, post-tension repairs, waterproofing, and painting. We've been in business for over 21 years, operating from our two locations, West Palm Beach and Aventura. I'll be happy to help you with achieving your recertification for your building, 40, 50, or 60 years. And I'll be happy to do also a free walkthrough and go over any engineering drawings, quantities, specs that you have. We are taking pride of our company that we are doing everything in-house, no subcontractors, and related to concrete repairs and painting, and also holding a very high performance bond capacity. So with that being said, I'll be happy to help, and I'll leave my information in the chat box. Thank you.
Great. Thank you so much. I want to say good morning to Damaris Cabrera. She's with Clarkson and Varick. Tell us about yourself and what is the elevator business doing now?
Good morning, Peggy. Good morning, everybody. My name is Damaris Cabrera. I work with Clarkson and Varick, elevator consultants. we specialize in basically helping business owners, building owners, and managers to take control of the elevator systems. We make sure that the elevators are compliant. So we inspect to make sure that the contract is being fulfilled by your contractor. We help by doing this process and keep them honest. We help avoiding costly surprises. We all know that you have a contract for the maintenance, but all of a sudden you have a lot of extra bills. So we make sure that this is really, elevator is not everybody's expertise. So we are there to support the owners and the managers, as I mentioned, and then we can validate that information. In the process, we inspect the equipment, and we can also provide valuable information and what is happening, what you can expect, what you need to do with it, and especially for modernizations and impacted or triggered by the recent code upgrades. Also, when sometimes you're not happy with your contractor, you think that you're tied by the contract, we can also assist in the process, not only to improve their performance with the conversations, we work as a mediators, and but also to get you out of it if that's as a last resource, and to get a new one that really fits the needs of the elevators. So thank you, Peggy. Thank you, everybody.
All right, so this is a condominium board certification class, and there's a lot of condos out there, and y'all have a lot of elevators out there. So when you need some service, you're not happy with who you have, or you need a new elevator, please call Damaris, and she will be on the sponsor sheet. Next, I want to introduce the very lovely Dalia Anise, attorney, and tell us what you do with Legacy Life Plan.
Thank you, Peggy. Good morning, everyone. Happy Friday. My name is Dalia Anise. I'm an estate planning attorney, so I do wills, trusts, and capacity planning. But what I really do is I help keep families out of court and out of conflict. The last thing you want is when you lose a loved one, you're going to court and there's a judge who has no idea about your family dynamics, who has no idea about you, or the person that's deceased is making extremely important decisions on your behalf and for your family. Also, creating a heart-centered estate plan, taking account of all the family dynamics, whether it's a blended family, or if you have a child with special needs, or someone who doesn't know, a child who doesn't is not good with money. Creating a heart-centered estate plan avoids a lot of conflict in the family. And I say, once there's conflict and then there are lawsuits going on, the only people that win are the attorneys, and because they get very high attorney fees. The family, dragging a case in court for years and years does not help anybody. So again, heart-centered estate planning. I'm going to put my contact information. I'm also going to put a link for if you're interested to have a free phone consultation. You can schedule a meeting with me by using the link, and I'll put that in the chat. Thank you again, Peggy.
Okay, great. Thank you so much. And thank you for joining us. She's out of town. You guys are very important to her. All right, next I want to introduce Siobhan Heredia. She is the business developer for United Professional Engineering. And Siobhan, tell us about yourself and that dynamic president of yours.
Yes, good morning, everyone. Happy Memorial Day weekend. Peggy, thanks so much for honoring those who have gone before us. We are so excited that you all are here today. Again, I am Siobhan with United Professional Engineering. We specialize in all of your structural engineering needs, especially concerning condos, with all of the new legislation that's out to protect the integrity of your investments, the integrity of your structures. This is not something that you want to miss out on, this opportunity. So we do all things milestones, recertification inspections. One thing about us is that we're a one-stop shop. So all of the needs, we get to oversee the project from start to finish, which is very supportive, saves time, and just helps execute with excellence. As Peggy mentioned, our president and owner, Carmelo Giglio. He has been serving Florida for 25 years. He is the standing president of the Florida Structural Engineers Association. So he is a top leader in the industry all across the state, has helped write the legislation to protect condos and buildings from the tragedy at Surfside. So we are here to serve you. Any questions that you have, I will leave my information. We're here to help. We're here to answer your questions. And yeah, have a great day.
Peggy, you're on mute.
Like Peggy might be frozen. I'll go ahead and up and introduce myself. Maybe I'm next on the list, maybe not, but Peggy, I'm sure will adapt. Matt
Go
Queasley with
ahead. Sorry.
Advisors. Thank you. Thank you. I'm a 25-year veteran of Reserve Advisors. I'm a professional engineer and a reserve specialist. We focus on reserve studies. Reserve Advisors is the nation's largest provider of reserve studies. We work in 50 states and 30 countries. But we do a lot of work in Florida. We've got several engineers throughout our team here. I have 60 engineers total and cover all parts of the state. Been very involved with the legislature on the new structural integrity reserve study requirements and some of the changes that have occurred recently. So we're happy to provide any consultations. So I'll put my contact info. You can reach out via email or give me a call, do free consultations. Also put a link for a free proposal. We're doing a lot of second opinions on structural integrity reserve studies, and I'm also excited to be teaching a class next week with this organization. So hopefully you can tune in on Tuesday for an extensive class on budgets and reserves. And lastly, I'm a condo board member as well, so I appreciate all of your effort and time in there. And I know you don't get enough for all the condo board members out there. Don't get enough thank you. So thank you for all that you do in creating a welcoming and comfortable environment for people to live in and protecting this industry. So thank you for all you do and have a great weekend.
Absolutely. Thank you so much. And I apologize for the intro on mute. Next, I would like to just mention and introduce briefly the sponsors who could not make it today, starting with the national company, Benjamin Moore. Rudy Forehand is a long time, actually 35 years down here in South Florida as a representative. He got lured into moving his son. So let's bid him good times this weekend. But as you know, Benjamin Moore is a manufacturer of paint and very widely used all over the state. What Rudy does is he goes around and he will evaluate your building, give you some consulting at no charge, and work with the painting companies that use Benjamin Moore. Next, I want to move and introduce Hafer Company. They're a CPA company that is all over the state of Florida with 4 offices. Their senior representative is Nicole Johnson out of Palm Beach Gardens. She is a partner as well as the operations manager. So her name, as well as Mark Landez, he'll be on there also as an audit principal contact on the sponsor sheet. Lastly, I want to mention COA Solutions of Florida. Daniel Baum is the founder and the CEO. He's an insurance broker that provides a lot of additional services, evaluating policies, and he's been saving people or condominiums a lot of money lately. So reach out to him if you're looking for new insurance. Okay, one more thing before I turn it over. Some of you have logged on after the 9 a.m. period, so just be sure and stay on all 4 hours as much as you can so that you do get a certificate that is required by the DVPR to be certified. And please put your questions into the Q&A. I see a lot of chat activity, but questions go into Q&A. They are being recorded. If we don't get to them, Brian Barcelona will be the one to return your information. So that is going to let me turn over the meeting to Jamie. Jamie, she is our moderator for today, Jamie Gelfand, and you can take it from there with Brian. Thank you.
Thank you, Peggy. Thank you all the sponsors. We really appreciate your participation. I just want to remind everybody that if you're on this class listening to the presentation, you will be receiving an email in approximately 10 days from Brian. In the subject line, he will have today's date and the name of the class. So there's been a lot of people questioning if they've been registered or that we can't see you. None of the attendees are visual, only the sponsors are visual. So Brian, ready to go?
Yes, I am. Thank you so much, Jamie, and thank you, Peggy, for the introduction. You guys are doing a great job. So I'm going to pull this up and we're going to start. Now, my name is Brian Barcelona. I'm going to be your instructor for today. I been in the industry for over a decade, managing communities, and I currently we manage Limestone Property Management. We currently manage several different properties around the state, whether that is garden style, whether that is a high rise, whether that is 55 and over. We have experience in all of it, and can't wait to help you volunteers learn more about what it is to be on your board of directors and what's going to be expected and what the state is going to be holding you to now as a director for your building. Now, it's important to note that this is not a legal update. We are not attorneys. We are not giving you legal advice. But again, this is going to give you that certification that the state requires in order for you to be to satisfy the requirements by the state. So with that being said, I'm going to get right into it. We're going to take a minute. And by the way, just a heads up. So as you know, this is a 4-hour course. So we're going to be taking regular breaks throughout. But that's still encouraging you to please ask your questions through the chat, through the question and answer portal. Jamie's going to be reviewing it. There is a lot to go over, but I've mentioned several times this morning already, I speak pretty fast. So so it helps when there's more to talk about versus just reading what's on the slide. So a little overview of the course. We're going to be talking about the budgets, about reserves, elections, records maintenance, bids, and contracts. Now, there are some things coming down the pipeline that are sitting at the governor's desk. He hasn't signed them into law just yet. And it's going to really change a lot of the things that you're probably used to at the moment, especially when it comes to reserves and the structural integrity reserve study, which when we get to, I'll speak a little bit more about that, what may be coming down the pipeline. And for managers, if some of you are managers yourself, there's also going to be some changes for management firms and what's expected of managers as well. So there's definitely some things, very exciting things to keep at the forefront of our mind. So we're going to start off with budget meetings. At any meeting at which a proposed annual budget of an association will be considered by the board or unit owners shall be open to all unit owners. At least 14 days prior to such a meeting, the board shall hand deliver to each unit owner, mail to each unit owner at the address last furnished to the association by the unit owner, or electronically transmit to the location furnished by the unit owner for that purpose a notice of such meeting and a copy of the proposed annual budget. An officer or manager of the association or other person providing notice of such meeting shall execute an affidavit evidencing compliance with such notice requirement, and such affidavit shall be filed amongst the official records of the association. So main thing to worry about here, of course, is 14 days and how it is you're giving your notices for your budget meetings. Most people are, most associations are pretty comfortable with that. So we don't get too many questions about that. But if a board adopts, and there's also some changes about this, so I'm going to finish reading it and I'll explain that to you. So if a board adopts in any fiscal year an annual budget which requires assessments against unit owners which exceed 115% of assessments for the preceding fiscal year, the board shall conduct a special meeting of the unit owners to consider a substitute budget if the board receives, within 21 days after adoption of the annual budget, a written request for a special meeting from at least 10% of all voting interests. The special meeting shall be conducted within 60 days after adoption of the annual budget. At least 14 days prior to such special meeting, the board shall hand deliver to each unit owner or mail to each unit owner at the address last furnished to the association a notice of the meeting. An officer or manager of the association or other person providing notice of such meeting shall execute an affidavit evidencing compliance with this notice requirement, and such affidavit shall be filed among the official records of the association. Unit owners may consider and adopt a substitute budget at the special meeting. A substitute budget is adopted if approved by a majority of all voting interests unless the bylaws require adoption by a greater percentage of voting interests. If there is not a quorum at the special meeting or a substitute budget is not adopted, the annual budget previously adopted by the board shall take effect as scheduled. So there is a new bill that's out there right now, and you could do some research on it as well, because currently, as you read here, if the budget is over 115%, then the owners have the right to petition to the board and say, hey, this budget's too high. But then the onus was on the owners to then submit a budget for that meeting. The unit owners may consider and adopt a budget at a special meeting. Now, at least potentially what's going to be changing is the board will have to be the ones to write the budget. So it's not going to be, well, if you don't like our budget, make your own, present it to us. It's if enough owners are going to be in agreement with the budget being too high, or at least over 115%, then the responsibility is going to be on the association to revise the budget and make a new one. I think that should have kind of always been the case. Most owners don't really understand how to make a budget and budget creation and things of that sort. At the same time, that's also going to take more time, more money, going to be a lot of course, I would not be surprised, legal fees when these things do arise. So it's something to just kind of keep an eye on. As of right now, like I said, it's not signed into law, but that's kind of what's sitting on the desk is if there is a claim that the budget is over 115%, now the board will have to make a new one versus the owners being the ones to make a new budget. So any determination of whether assessments exceed 115% of assessments for the prior fiscal year shall exclude any authorized provision for reasonable reserves for repair or replacement of the condominium property, anticipated expenses of the association which the board does not expect to be incurred on a regular or annual basis, insurance premiums or assessments for betterments to the condominium property. If the developer controls the board, assessments shall not exceed 115% of assessments for the prior fiscal year unless approved by a majority of all voting interests. Reserve accounts. In addition to annual operating expenses, the budget must include reserve accounts for capital expenditures and deferred maintenance. These accounts must include, but are not limited to, roof replacement, building painting, and pavement resurfacing, regardless of the amount of deferred maintenance expense or replacement costs, and any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. So this is something else that's kind of on the desk right now with the governor. I believe it's House Bill 913, and it's again kind of giving a little bit more leeway to associations on doing their reserves. If they could, if an engineer is willing to say that they could offset, let's say, the maintenance of their roof another year, 2 years, whatever it may be, extending that deadline from what they currently have, which is I think at the end of the year they have to have the reserve fully funded. So again, hasn't taken effect yet, but it's coming down the pipeline. At this point, reserves have been talked about so much that most associations are compliant with these laws, but everybody's different. So if you're someone who's still kind of waiting to see what happens, pay attention because there is a lot coming down the pipeline. So, yes, Peggy.
I was going to ask Matt if you wanted to say anything, if he's still on. Is Matt Cusley still on?
Matt had to go.
Okay, all right. Well, just because of that business. Okay, thank you.
Yeah, that was his forte. Yeah, it's at this point, like I mentioned, there's been so much talked about it already that these changes are, and they're welcome changes, quite frankly, because so many people have been slammed by these reserve laws and making sure that they have to be fully funded by the end of the year. So seeing that there's a there's a potential to even extend that deadline, and there's even a potential on how to fund the reserves. You may not necessarily have to have cash on hand according to what may be coming down the pipeline. Maybe you'll be able to finance it. So can you prove that the association is financeable? That could help, which is going to help with your expenses. We'll see if that gets passed. It's there in special session, but I would have loved to have him on here to have his 2 cents. We have another question here by Anuna. I don't know if that's on purpose or if that's a guess. Do you know, Jamie?
I'm tracking the questions, but I'm going to wait till they are applicable to the section you're working on.
Okay, yes, ma'am. So continuing on, the amount to be reserved must be computed using a formula based upon estimated remaining useful life and estimated replacement costs or deferred maintenance expense of the reserve item in the budget adopted by an association that is required to obtain a structural integrity reserve study. Reserves must be maintained for the items identified in paragraph G for which the association is responsible pursuant to the declaration of condominium, and the reserve amounts for such items must be based on the findings and recommendations of the association's most recent structural integrity reserve study. With respect of items for which an estimate of useful life is not readily discernible, or with an estimated remaining useful life of greater than 25 years, an association is not required to reserve replacement costs for such items, but an association must reserve the amount of deferred maintenance expense, if any, which is recommended by the Structural Integrity Reserve Study for such items. Section 718.112.2F, the association may adjust replacement reserve assessments annually to take into account an inflation adjustment and any changes in estimates or extension of the useful life of reserve item caused by deferred maintenance. The members of a unit owner controlled association may determine by majority vote of the total voting interest of the association to provide no reserves or less reserves than required by this subsection. For a budget adopted on or after December 31st, 2024, the members of a unit owner controlled association that must obtain a structural integrity reserve study may not determine to provide no reserves or less reserves than required by this subsection for items listed in paragraph G, except that members of an association operating a multi-condominium may determine to provide no reserves or less reserves than required by this subsection if an alternative funding method has been approved by the division. Ironically enough, go ahead.
Brian, there is a question in the chat from before, the slide before. Freddie is asking, did you say 115% or 15%?
115%.
Okay,
150%.
thank you.
So reserve funds and any interest occurring thereon shall remain in the reserve account or accounts and may be used only for authorized reserve expenditures unless their use for other purposes is approved in advance by majority vote of all the total voting interests of the association. Before turnover or control of an association by developer to unit owners other than the developer pursuant to statute 718.301, the developer controlled association may not vote to use reserves for purposes other than those for which they were intended. For a budget adopted on or after December 31st, 2024, members of a unit owner controlled association that must obtain a structural integrity reserve study may not vote to use reserve funds or any other interest occurring thereon for any other purpose other than the replacement or deferred maintenance costs of the components listed in paragraph G. Basically, if this is a long-winded, but if you have a reserve account, you can only use that reserve account for what it's reserved for. Most people already know that. There's little nuance that kind of gets involved with these sort of things. You know, sometimes, let's say you reserve to do a roof replacement, and now part of the roof replacement, now you're going to have to extend the project because now you have to replace other parts of the building that may not have been budgeted for. So if it's not part of the roof, good rule of thumb is you probably would have to pass another special assessment or update your reserves in order to do so. The important thing is also to remember is having the majority vote of the owners. So these are not something that the board can decide. It's a total of all the voting interests. So everybody who is considered a member of the association, typically owners. I have seen some cases, believe it or not, where you are where the association docs, it doesn't really say you have to be an owner to be a member of the association. I've seen it where as long as you're a resident. So that meant that there were tenants that had voting interest in the association. So make sure you're very familiar with your docs, because if your docs do not clearly specify that you have to be an owner to be a member of the association, then that's gonna lead to some interesting conversations. I've seen and personally been part of situations where tenants were running for the board, and so you definitely gotta be on top of your docs with that one. With that being said, the only voting interests that are eligible to vote on questions that involve waiving or reducing the funding of reserves or using existing reserve funds for purpose other than purposes for which the reserves were intended are the voting interests of the units subject to assessments to fund the reserves in question. Proxy questions relating to waiving or reducing the funding of reserves or using existing reserve fund for purposes other than purpose for which the reserves were intended must contain the following statement in capitalized, bold letters in a font size larger than any other used on the face of the proxy ballot. So very conspicuously, waiving of reserves in whole or in part or allowing alternative uses of existing reserves may result in unit owner liability for payment of unanticipated special assessments regarding those items. There may still even be someone who says they didn't see it, even with big, bold letters, but you still have to put it there. That's what the state's requiring.
Before you move on, Brian, there's a question. Are they still able to do pooled reserves?
We're actually about to get into that right now, and I believe you can, but we're going to get into that right now. A residential condominium association must have a structural integrity reserve study completed at least every 10 years after the condominium's creation for each building on the condominium property that is 3 stories or higher in height, as determined by the Florida Building Code, which includes at a minimum a study of the following items as related to the structural integrity and safety of the buildings: the roof, structure, including load-bearing walls and other primary structural members, and primary structural system as those terms are defined in statute 627-706, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows and exterior doors, any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000, and a failure to replace or maintain such item negatively affects the items listed in subparagraphs A through G, as determined by the visual inspection portion of the structural integrity reserve study.
So before you move on from H, one of the items that the Florida legislation is looking at is increasing that $10,000 to $25,000. So this is a good time that everybody should, if you're not already aware of CAI, Community Association Institute, that is, they have a lobbyist that works with the Florida legislation to get an important legislation passed, and they have been working diligently for the last few months to get these changes made. So if you want information on CAI, I can put that in the chat.
Thanks, Jamie. And you know, I just also want to mention back to the question about pooled reserves. A lot of the statutes, that the way it's written, especially for situations sort of like how, if you could do pooled, like fully, like how you're going to do your reserves, it's you'd have to review your condo docs. You really do, because because the way it's written typically is you're going to see wording in there that says the association could have a pool reserve, let's say, with vote of the membership, right? And so now you're going to have to look in your docs and see if that's even allowed or not, because sometimes your docs do allow it. Sometimes it's a board decision. Sometimes it's a membership decisions. The nuances that get involved with pooled reserves, you really have to make sure your docs are clear on that, because that's something that's going to be your Bible on how you run your building. So the state, of
And
course.
to support that, the only items that would be able to be pooled would be those in H.
Mm-hmm,
All of the other reserve items need to be standalone.
mm-hmm. And now with that potentially new law, with $25,000 or more, that's going to again give owners that kind of flexibility, right? Where now they know if that's a much higher threshold, essentially doubled of what they currently had, which was $10,000
If in fact it does
if
pass.
it passes.
So that's why it's important for people to know that legislation was extended. It normally ends in May, but it's been extended into June, so that all of these items that they're working on have not been finalized. And then it's whether the governor will sign them into law or not.
Mm-hmm, mm-hmm. And adding to that, I know some of the bills that I've mentioned, they're taking effect July 1st. So it's going to be rather quickly if these things, they do pass. So all the more reason to stay up to date as much as possible. Go to, not in addition to doing these kind of courses, which are good, but going to legal updates. You're always going to learn something that's happening in the condo world. So structural integrity reserve continued. A structural integrity reserve study is based on a visual inspection of the condominium property. A structural integrity reserve study may be performed by any person qualified to perform such study. However, the visual inspection portion of the structural integrity reserve study must be performed or verified by an engineer licensed under Chapter 471, an architect licensed under Chapter 481, or a person certified as a reserve specialist or professional reserve analyst by the Community Association Institute or the Association of Professional Reserve Analysts. So as you can tell, it says visual inspection. I've had a couple clients in the past who they weren't sure what typically entails with these inspections, but because there's when it comes to doing building inspections, there's all kinds of ways that engineers can do it. They have x-rays, you have sound testing, you have sonar. There are so many ways that they could test the building. So a lot of time when people hear these studies happening in their building, they're expecting to see a team of people come into their building with all this specialized equipment, and they're gonna essentially cut holes into their wall, and they're gonna test but that's not what's required. It's a visual inspection. So you're gonna have a licensed engineer, a licensed person who's approved, or a person who's approved to do these inspections go in. And just like that, they're going to look, and based off of their professional experience, based off of their judgment, they're going to tell you what the lifespan is. They're going to tell you how much you should put towards saving, towards the reserves for these items. And then of course you're going to have to work with the association, with the board members. So a lot of times maybe some owners who've been there a long time, who may have documentation, who may have the meeting minutes. So because again, it's a visual inspection, and the engineer may see something, but if you have documentations, let's say you have whether that's meeting minutes, whether that's reports that's showing when the association went back and did repairs, and these are the contracts from when we did it, so it should last a little bit longer. Like these sort of things help. And you want to make sure that you have a good manager and a good system in place with your record keeping, because when you're doing these inspections, these records could save you thousands, and not having them, of course, could be very costly. Go ahead, Peggy.
I just wanted to interject because this is for new board members and the ones that have experience, just for referral or reviewing in your mind. When every legislation session is over, there is going to be a litany of things that are particularly for condominiums, also separate for homeowner associations. And you can get these law changes or, modifications directly from a website on the Department of Business and Professional Regulations or your property management company, and those will be available July 1st. So for new members, this is not going to get you through the next 5 years that this is certified for. without reviewing the laws each and every year as your own responsibility as a board member. So I just like to reiterate that, because a lot of times new board members, you're not really realizing the scope of your responsibility as a board member. You're running a business, and these new law changes every single year are going to be available the first week of July, and you should refer to them. They're usually posted on the DBPR website, and I'm going to try to send out whatever information I have as well. So good luck with that. I just wanted to mention it. I think it's very important.
Thank you, Peggy. All the more reason, again, to have a good team with you, because there's so much. You'll never do it all yourself. You need to make sure you have a really good support team, good management company, good manager on site if you have somebody on site. If otherwise, you're gonna be spending a lot of time just reading laws and dealing with complaints. No, that's not why you get onto a board of directors. You get on the board, you're taking these courses so that way you can make sure that your building is compliant, that the building is safe, and that you're knowledgeable and you're up to date with what's happening. But like Peggy said, keep learning, because there's no way you're gonna walk away from all this and knowing everything. You're always, even me, as I've been teaching this course for like several times now, been in the industry, but every time I read it, there's something new that comes out and jumps out to me. So you got to stay up to date.
Just one more thing. It reminds me of how everybody, you have a baby or you have a new infant in the family. There's no book on how to be a good parent or a good father or whatever, it's just crazy. But, maybe we need to write a book, Brian, or even Jamie, you got a lot of experience, but what is really expected of a board member. So there's nobody out there, you're going to say, why didn't everybody tell me this when I joined the board, or if nobody said this, or it's just like having a baby.
Yep.
Good luck.
Yep. And my baby's 1 year old, and I think about that all the time. I'm like, where's your manual? I don't know what I'm doing. Oh God. Structural integrity reserve study. At a minimum, a structural integrity reserve study must identify each item of the condominium property being visually inspected, state the estimated remaining useful life and the estimated replacement cost or deferred maintenance expense of each item of the condominium property being visually inspected, and provide a reserve funding schedule with recommended annual reserve amount that achieves the estimated replacement costs or deferred maintenance expense of each item of condominium property being visually inspected by the end of the estimated remaining useful life of the item. Man, these paragraphs that they write are so long, let me tell you. So the structural integrity reserve study may recommend that reserves do not need to be maintained for an item for any. Let me read that again. The structural integrity reserve study may recommend that reserves do not need to be maintained for any item for which an estimate or useful life and an estimate of replacement costs cannot be determined, or the study may recommend a deferred maintenance expense amount for such item. The structural integrity reserve study may recommend that reserves for replacement costs do not need to be maintained for any item with an estimated remaining useful life of greater than 25 years, but the study may recommend a deferred maintenance expense amount for such item. This paragraph does not apply to buildings less than 3 stories in height, single family, 2 family, or 3 family dwellings with 3 or fewer habitable stories above ground, any portion or component of a building that has not been submitted to the condominium form of ownership, or any portion or condominium of a building that is maintained by a party other than the association. So I know it looks like we have a break coming up, ladies. So are there any questions that people have asked? Otherwise, we'll just go straight to our break.
I can throw 1 or 2 of these at you. I'm not sure that you will ever address them. So the first question from Lewis: when an owner passes away and the ownership of the unit is transferred as part of probate, we are not notified of the transfer. The court does not apparently, at least in Broward, require notice to the condominium. The condominium is therefore not aware of the change of ownership. Is there a remedy for this? Should the probate attorney be compelled to notify the condo association of the transfer, contact information, and other pertinent information? We only found out of one such circumstance by searching the assessor's site.
I mean, in this case, one, before I say anything, definitely get with your attorney and ask them about that. I would say in my experience, because I've had this happen where a family member died, right? And it went through probate. Somebody takes over the unit. The unit's been vacant, but you'd even know who really is the owner until you start sending notices, or you got to send the collections, and you look on the county record, you're like, wait, they transferred title, a year ago, and we didn't know. That it happens. I mean, like I said, I've seen it happen in buildings that I've ran. The only thing you could do is just kind of move forward. Yeah, you obviously a lot of times there are rules in place by the association that you're not allowed to transfer title without board approval or without the association approval. But these things do happen. So what kind of recourse could there be? Again, you got to get with your attorney on that one. Because and then when you figure it out, tell them to let me know, because I always say the best bet is just sort of move forward, find out if somebody's living in there, because you never know who's living in there. And if nobody's living in there, if they're not behind in their maintenance dues, maybe best to be one of those things that just keep an eye on it, let it go.
And the rest, I believe you're going to address through the rest of this. So that's it for that one.
So on that note, we're gonna take a 5-minute break, and then we're gonna come back and do another module. Section 2, we're gonna be talking about elections. So if you have any questions about elections, think about that now. Put it in the Q&A. Jamie and I will vet that, and we'll discuss it when we start again. So time right now is 9:50. I say we be back here at 9:55. How did that sound, ladies?
Perfect. Thank you.
All right, 9:55. Next time I want to add like a timer, like a visual timer in here, you know? So it's about that time. Say 9:55, it's 9:56. Get it to work. On to elections. Got my sparkling water. So we're going to discuss an overview of the election process, how the whole election works, the framework in it, in which it operates, and of course, the importance of transparent elections and maintaining trust with the community. Transparency is the key to running a successful condominium, a successful building. There are no secrets. Everything is open. You're in a glass house, people. Election procedure, section 718, 112, 2D. The members of the board of a residential condominium shall be elected by written ballot or voting machine. Proxies may not be used in electing the board in general elections or elections to fill vacancies caused by recall, resignation, or otherwise, unless otherwise provided in this chapter. This subparagraph does not apply to an association governing a timeshare association. Something else that's in the pipeline is they're going to be adding potentially, this is not set in stone, that's why you're not seeing it here, but they may be adding the ability to vote by email, which to me is very convenient. I mean, who wouldn't like to be able to just send an email, this is who I vote for? But at the same time, B, it's not going to be secret ballot. If you send an email, I know who sent the email. And then B, it could lead, when I read that, I was thinking, what if somebody challenges and says I didn't write that, like that's not for me. So who knows? They're going to update the wording. They're going to change it. It's not approved yet, so it's still up in there in the works, but that's going to be interesting to see if that comes into fruition and how that's going to look and what kind of wording they're going to put in there to protect the whole election procedures. At least 60 days before a scheduled election, the association shall mail, deliver, or electronically transmit by separate association mailing or included in another association mailing, delivery, or transmission, including regularly published newsletters to each unit owner entitled to a vote, a first notice of the date of the election. A unit owner or other person desiring to be a candidate for the board must give written notice of his or her intent to be a candidate to the association at least 40 days before a scheduled election. So 60 days before your annual meeting, your first notice goes out. The notice is just telling them the date of the election. You're not including the agenda. You're not including the ballots. You're not including the proxies. You're just telling people, hey, there's going to be an annual meeting 60 days from now. And if you would like to be on the board of directors or run for the board, you have this intent to be a candidate. You could provide that to them. I've seen that done. It's just a sheet. Intent to be a candidate. They put their name. They send it back. Or they could just, there's no real specific sheet you have to use. It could even be it could be a napkin. They can write it on a napkin and say, hey, I want to be on the board and hand it to you. If it's within that 40 days, well, they just gave in their intent. Election procedures, together with the written notice and agenda as set forth in subparagraph 3, the association shall mail, deliver, or electronically transmit a second notice of the election to all unit owners entitled to vote, together with a ballot that lists all candidates not less than 14 days or more than 34 days before the date of the election. So your second notice is when you send your agenda, when you send all those goodies. So that's when, so the first notice is typically a lot smaller, may be able to fit in an envelope. The second notice, depending on how many intents to run you get, that's another thing you're gonna have to include in here, is their intents to run. And the next slide is actually going to cover information sheets. So I'll just get into that right now, because you're gonna have to include that with the second mailing. So first mailing, just to notice. Second mailing is the agenda and the people who want to be on the board. And if they submitted one, you're going to send their information sheets. So upon request of a candidate, an information sheet no larger than 8.5 by 11 inches, a standard paper, which must be furnished by the candidate at least 35 days before the election, must be included with the mailing, delivery, or transmission of the ballot, with the cost of mailing. With the cost of mailing, delivery, or electronic transmission and copying to be borne by the association. The association is not liable for the contents of the information sheet prepared by the candidates. In order to reduce costs, the association may print or duplicate the information sheets of both sides of the paper. So, very important to know here, you have to send it out. So if somebody wants to include a scathing letter about the current board, or maybe just a lovely letter about the current board and how they want to help the current board, because people could be nice too. So you have to include it. You have to include all of it, but you're not responsible for it, and the association has to cover the cost for the mailings of the information sheets. There's no reason for elections to get contentious, in my opinion. There really isn't. You follow the rules, you should be in good hands. The division shall by rule establish voting procedures consistent with this subparagraph, including rules establishing procedures for giving notice by electronic transmission and rules providing for the secrecy of ballots. Election shall be decided by plurality of ballot cast. There is no quorum requirement. However, at least 20% of the eligible voters must cast the ballot in order to have an election. And of course, you have to have enough people who want to be on your board to have an election, which we talk about that too. But if you have 5 seats and 4 people run, what are you voting for? There's 5 open seats, 4 people, everybody joins. A unit owner who violates this provision may be fined by the association in accordance with statute 718-303. A unit owner who needs assistance in casting the ballots for the reasons stated in statute 101.051 may obtain such assistance. The regular election must occur on the date of the annual meeting. Notwithstanding this subparagraph, an election is not required unless more candidates file notices of intent to run or are nominated than board vacancies exist. Footnote: requirement for an election to be valid if at least 20% of eligible voters cast a ballot. And also, what I was saying before, if you have more people, if you have more vacancies than you do candidates, you don't have an election. If you have more candidates than you have vacancies, you have an election. So in this scenario that I brought up before with 5 people, if you have 5 vacancies and you have 6 people who want to run for the board, you could have an election, because now you have more candidates than you do vacancies. A director of a board of an association of a residential condominium shall certify in writing to the secretary of the association that he or she has read the association's declaration of condominium, articles of incorporation, bylaws, and current written policies, that he or she will work to uphold such documents and policies to the best of his or her ability, and that he or she will faithfully discharge his or her fiduciary responsibility to the association's members. And then 2, submit to the secretary of the association a certificate of having satisfactorily completed the educational curriculum administered by the division or a division-approved condominium education provider, which is what you're doing right now. The educational curriculum must be at least 4 hours long and include instruction on milestone inspections, structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines and notices, and meeting requirements. You kind of see where we are in the timeline. We're here. Well, we're here. We're gonna get to here. Each newly elected or appointed director must submit to the Secretary of the Association the written certification and educational certificate within 1 year before being elected or appointed, or 90 days after the date of the election or appointment. A director of an association of a residential condominium who was elected or appointed before July 1st, 2024, must comply with the written certification and educational certificate requirements in this subparagraph by June 30th, 2025. I think most people are after July 1st at this point. Some associations, you have terms that last a long time, but for the most part, everybody should be under the 90 days for the most part. The written certification and educational certificates is valid for 7 years after the date of issuance and does not have to be resubmitted as long as the director serves on the board without interruption during the 7-year period. A director who is appointed by the developer may satisfy the educational certificate requirement in subparagraph 2 for any subsequent appointment to a board by developer within 7 years after the date of issuance of the most recent educational certificate, including any interruption of service on a board or appointment to a board and another association within that 7-year period. They must like the number 7. 1 year after submission of the most recent written certification and educational certificate, and annually thereafter. So this is not the end of your education, this is the beginning, because annually, every year, starting next year, a director of an association of a residential condominium must submit to the Secretary of the Association a certificate of having satisfactorily completed at least 1 hour of continuing education administered by the division or division-approved condominium education provider relating to any recent changes to this chapter and the related administrative rules during the past year. So really, CE course, continuing education, a legal update. You have to do 1 hour. So every year after this. A director of an association of a residential condominium who fails to timely file the written certification and educational certificate is suspended from service on the board until he or she complies with this subparagraph. The board may temporarily fill the vacancy during the period of suspension. The secretary shall cause the association to retain a director's written certificate and educational certificate for inspection by the members for 7 years after a director's election, or the duration of the director's uninterrupted tenure, whichever is longer. Failure to have such written certification and educational certificate on file does not affect the validity of any board action. Any challenge to the election process must be commenced within 60 days after the election results are announced. Any questions, Jamie? Nothing?
Yes, I have a question from Jessica. How long can a person stay on the board, especially in the president's seat? And does the community get a say in who takes what office or position of the board?
That may be specific to your building. Typically, anybody who wants to be on the president, typically they're the president for the duration of their tenure on the board. Now, if that person wants to step down from being the board president, they can. There may be ways to remove that person from president, not from the board, but from president, if you're depending on what your docs say. Because the docs will give you some direction onto what it takes to remove somebody's officer position. So you may want to appoint another board president, which is very typical as well. It happens. The board, let's say you have a board of 5 people, whatever, 5 people, and 4 of the 5 people don't like the current president. Well, you 4 could then say we're gonna remove him as president and put a new person as president because you're the majority. Looking at what your docs say. And then there's also one step further, I'd say the owners also could have a say in it, depending on what your docs say. Not very common. Typically, what the owners are electing is who's going to be on the board. And then from there, the board is deciding who's going to take what officer position. As you could tell, there's a lot of leadership that comes with being on the board. That's why you're on your board of directors, because the state is trusting. There's too many, because the state knows there's too many owners to get anything done. So we're going to have a select few of these owners make the decisions on behalf of these owners. And that's why you have a board of directors in the first place. And out of you board of directors, you have to decide who amongst you is going to be the president, who's going to be the treasurer, who's going to be the secretary, who's going to be a director. And then you operate it that way.
And then her follow-up question was, is there any term limits?
Yeah, I believe it was what, 7?
And I Googled it. It's 8-year term with the first impacting happening in 2026, because this law went into effect July 1st, 2018. But of course, like everything else, there are exceptions. A board member can continue serving if they receive at least 2/3 of the vote cast in an election, or if there aren't enough eligible candidates to fill the board vacancy.
That is I will say this, that's a big threshold, 2/3. That means the majority of people have to want them on the board again.
To stay, right.
Yeah. And then they could stay longer than 8 years. Or what was the other one, Jamie? I think, nobody else running.
Or no one else is running.
Yeah, so they run unopposed. So if you run unopposed, then you could continue after 8 years.
Correct. And then the next question, we have a board member who continually quits and reappoints herself back on the board. Is there any way to bar her from rejoining the board?
Well, I mean,
she reappoint herself.
Yeah, like once you get off, you're not on the board. You can't.
Right, she can't reappoint herself.
Reappoint yourself. That doesn't make any sense.
No, either the board reappoints her back on the board.
Yes.
That would definitely be a recommendation to go to the association's attorney on that.
Because if the board would have to put her back, but if they don't want her back, then she can't come back.
Correct.
Now in here, it talked about suspension, right? So that could be another thing. Maybe she's saying, I'm taking a leave of absence. You could do that. You could say, I'm stepping down, I'm stepping away. I'm sick, whatever reason. This is temporary. I will be back in a month. That's fine. But I don't know if that's what's happening here or not. So again, like you said, attorney question. Ask your attorney or get my information. We could talk more after this. Unless otherwise provided in the bylaws, any vacancy occurring on the board before the expiration of a term may be filled by the affirmative vote of the majority of the remaining directors, even if the remaining directors constitute less than a quorum, or by the sole remaining director. In the alternative, a board may hold an election to fill the vacancy, in which case the election procedures must conform to subparagraph 4A. Unless the association governs 10 units or fewer and has opted out of the statutory election process, in which case the bylaws of the association's control. Unless otherwise provided in the bylaws, a board member appointed or elected under this section shall fill the vacancy for the unexpired term of the seat being filled. Real story. This actually just happened in the building that we manage, where it was a small board to begin with, but at the meeting they like 2 of the 3 decided to step down. They said, we're done, we're not doing anything else. They were fed up. So there was one more, so there was literally only one director. So but as it says here, you could appoint another one. So she said, did anybody else want to be on the board? And we were quickly able to get those seats filled. And they had an organizational meeting, which you'll have to have again. But then kind of like I said, their term was only good until the annual meeting. So then of course you have the annual meeting, and then the annual meeting, they were on the board until the annual meeting, and then they ran again because they would have to run again. You don't get a whole new year if you come on in the middle of the term. you get what's left of the term. So so that's what we did, but it does happen. It does happen, but you don't have to panic. She was panicking though. I can't blame her when your whole team decides to quit on you like that. It's like, oh man, what do you do? But fortunately, she's able to get some new people on the board. So this chapter does not limit the use of general or limited proxies, require the use of general or limited proxies, or require the use of a written ballot or voting machine for any agenda item or election at any meeting of a timeshare condominium association or non-residential condominium association, notwithstanding subparagraph B2 and subparagraph 4A. An association of 10 or fewer units may, by affirmative vote of a majority of the total voting interest, provide for different voting and election procedures in its bylaws, which may be by proxy, specifically delineating the different voting and election procedures. The different voting and election procedures may provide for elections to be conducted by limited or general proxies. And then shameless plug here, I believe Vinteum has voting software in their Neighbors program. So if you have a good system with one of your vendors or somebody who don't, they could handle the election process online. Very convenient. Makes it a whole lot easier for people, makes the night go quicker. And that's kind of what you want.
Hold on one second. Here's an interesting one. What happens if the entire board resigns at the same time?
That actually happened recently too. I heard that in the news. Doesn't happen much. I don't have any experience with it. But typically what happens is it goes into receivership. If there's
Correct.
nobody, and receivership is a court appointed attorney. And the court appointed attorney is now going to run your building. They're going to,
which is very expensive.
Very, very expensive, which is why most people don't do it. Because just imagine paying, an attorney, a lot of these attorneys are charging $500, $700 an hour. And now they're going to charge basically the association that to run it. If at all possible, avoid that scenario as much as you can. You're going to say something, Jamie?
Agreed. Nope, we're good.
The only voting interests that are eligible to vote on questions that involve waiving or reducing their funding or reserves or using existing reserve funds for purposes other than purposes for which reserves were intended are the voting interests of the units subject to assessment to fund the reserves in question. Subject to assessment to fund the reserves in question. If you're not subject to funding it, you got nothing to say. We are flying through this chapter as well. This is a much shorter one, but I know the next one's quicker because we have another break coming up. Proxy questions relating to waiving or reducing the funding of reserves. Okay. Reserve fund for purposes other than purposes for which the reserves were intended must contain the following statement in capitalized bold letters in a font size larger than any other used on the face of the proxy ballot. Waiving of reserves in whole or in part or allowing alternative use of existing reserves may result in unit owner liability for payment of unanticipated special assessments regarding those items. No, it only makes these voting interests. Okay. And that's it. Now we're on another break time. I'm saying we're flying through this. Are there any questions?
No, the question's still open, I believe will be addressed.
Okay, because the next module we're going to be going to is records maintenance. Very important.
Yes, I have some for records maintenance.
Very good. A lot of people, this is always a big one too, because you always have those owners who, and they have a right to. Everybody has a right to the records, like I say, and boards sometimes get nervous. Like, what are they doing? Why are they looking at this? Why are they asking to see this? Because they can. And if they're asking, you got to give it to them. So with that being said, I think we should take a, we're going through this pretty quickly. So let's do a 6-minute break. Right now it's 10:20. Let's come back at Let's come back at 10:25. Keep it nice and round. We'll go from there. All right.
Thank you.
10:25, folks. All right, folks, we're back. Let's get right to it. Module 3, records maintenance. To ensure board members understand their legal responsibilities regarding the maintenance and accessibility of association records. That's our objective, of course. Like I said, I mean, put simply, you got to show them everything. It's very long, you'll see. Defining official records. Official records. From the inception of the association shall maintain each of the following items, if applicable, which constitutes the official records of the association. A copy of the plans, permits, warranties, and other items provided by the developer under Statute 718-301. A photocopy of the recorded declaration of condominium of each condominium operated by the association and each amendment to each declaration. A photocopy of the recorded bylaws of the association and each amendment to the bylaws, a certified copy of the articles of incorporation of the association or other documents creating the association and each amendment thereto, a copy of the current rules of the association, a book or books that contain the minutes of all meetings of the association, the board of administration, and the unit owners, a current roster of all unit owners and their mailing addresses, unit identifications, voting certifications, and if known, telephone numbers. The association shall also maintain the email addresses and fax numbers of unit owners consenting to receive notice by electronic transmission in accordance with subparagraph C5E. The email addresses and fax numbers are only accessible to unit owners if consent to receive notice by electronic transmission is provided, or if the unit owner has expressly indicated that such personal information can be shared with other unit owners, and the unit owner has not provided the association with a request to opt out of such dissemination with other unit owners. An association must ensure that the email addresses and fax numbers are only used for the business operation of the association and may not be sold or shared with outside third parties. If such personal information is included in documents that are released to third parties other than unit owners, the association must redact such personal information before the document is disseminated. However, the association is not liable for an inadvertent disclosure of the email addresses or facsimile numbers for receiving electronic transmission of notices unless such disclosure was made with a knowing or intentional disregard of the protected nature of such information. All current insurance policies of the association and condominiums operated by the association, a current copy of any management agreement, lease, or other contract to which the association is a party or under which the association or the unit owners have an obligation or responsibility. And then 10, bills of sale or transfers for all property owned by the association. Yes, my queen, Queen Peggy.
Oh, sorry, that caught me off guard.
I know.
I just would like to make a recommendation, having been on a board myself and just all these things coming into play, is to boards assign someone on the board to either work with your manager or make a committee to go through all these items, number 7, make sure like maybe one person is in control of getting the, or 2 people in control of getting the roster together. That is a huge responsibility. If you want your manager working on your property and doing the manager things that you're asking them to do, you have to help. That's also a responsibility of the board members. Also having a dedicated file on your website. First of all, having a good quality website, to put all this information in a file, label it, meeting notes, architectural file, legal notes, and break them down. And also your board certification certificates, put those in a separate file. I mean, this cannot all be done by your property manager for the hours that you're willing to pay the property manager. It would cost you a fortune. So try to do some of this yourself, make a committee, assign board members. If you have a lot of directors that aren't specifically president, vice president, secretary, or treasurer, the other board members got on the board to be helpful. They want to help. So, keep that in mind as well. So I really recommend this, especially hurricane season is coming, to get your roster up to date ASAP. Have a couple of meetings if you have to. Have a couple of days where people can come down to your clubhouse or to the office and sign in and make sure their information is updated. So good luck with that. I just wanted to mention that because I think it's extremely important.
No, that is, and I think on a list of best practices, that would be on the top of the list up there, because that is like you mentioned, that is such a big task, especially when you get to some of these bigger properties where you have, several hundred units. It's a lot to maintain just the owners. Somebody mentioned that there was a transfer and they didn't even know about that. So now add another layer of not just maintaining the owners, the list of current owners, but adding their contact information now, their emails, their phone numbers. That's a task in and of itself. If you could have a committee dedicated to making sure that's up to date, maybe once a quarter, bi-quarterly, once a year, something where they're going around, having people come to the office, doing something to check for, to make sure that the association still has their current contact information. That would be great. I cannot tell you how many properties I go to and you ask them, do you have their emails? Do you have their phone numbers? And they say, yeah, but we haven't updated it in, 3 years, in 2 years, in a year, in 6 months, 7 months. We don't know who the tenants are. We don't know how it's definitely up there. Good point. So
I
continue. Go
have
ahead.
2 questions before you go on.
Yes, ma'am.
Must records of all email and communication among board members be preserved?
Ooh, that's one of the questions. That's one of the things that are listed here. Yes. If you're having association business, over emails, that's open for inspection. That's open for inspection. Now, it gets kind of interesting because I've seen where people will, they'll use their personal email for association business. They're like, well, I don't want them going through my emails, and that makes sense. So what we've done in the past, if we've you'd have to provide it somehow. So whether that's via a flash drive, where you have to go now, you'll have to go inside your email and make sure everything is there, and and upload it to a flash drive. But I've seen it sometimes where, and once it starts getting litigious, where attorneys will ask to see the email, because if you're using it for the association business, owners have a right for it. They have a right to see emails that the board's sending, and because you're not acting on behalf, you're not acting in your own, and on your own accord, you're acting on behalf of the entity that is your condominium association.
So a good practice would be for board members to set up separate emails specific for the association work and not commingle it with their personal life.
That's a great way to drive it home. Exactly. Set up something separate. You don't have to have like a specific domain that says, let's say, president at Limestone Association. You don't have to do that. It could be a Gmail, but have something set up just for the association emails, if that's what you're going to do. Was there another question?
Well, sort of. Can someone's significant other be privy to all information if they are not on the board and not even an owner, like they share an email? But I think that goes back to what we discussed, that they should have a separate email specific for association business, and it should not be shared generically, right?
Yeah. I mean, I've seen that a lot of times, especially when somebody's been together for, 30 years, 20 years, 50 years. It's like that's their second brain. So, but they have to understand when you're working as a board member, you're a board member. Your spouse isn't. You are. So you have to be able to kind of separate that. It's tough. Believe me, I see it all the time. That's a very tough line to keep. I know if I try to keep something from my wife, I have to be very clear with what I'm doing. So we're both in good standing. So
So
it's
to confirm the next person's question, which is just reiterating what we just said, regarding board association emails, will this be part of the records request, or does this go through an attorney? And as you just defined, the emails are all part of the records request.
yeah. And we're gonna talk about how to do a records request. Like, because now it used to be at one point where if somebody did a records request, it was pretty easy. You could just say, here's the keys to the storage closet, there are the records, and that was sufficient. But now and we're gonna get into that more, but now when you do a records request, you have to tell them, you have to provide it. Number one, make sure you're providing it. Two, give them a list of what you're providing and what's not there. And then you have to have evidence that you made your best effort in getting them the information, whoever's requesting the information that they're requesting. We're gonna touch more on that. Peggy had a question. I called you Queen Peggy because you did this whole thing, so that's why I said Queen.
You're too kind, too kind. No, I just want to say, going back to the spouse situation and the other ones on the board, because you can only have one of a couple situation on the board. But if the other person, the spouse, violates anything that the board member's responsible for, they are the one that is responsible. So, they are damaging the reputation and the credibility of that board member, even though they are a spouse. So that's the only thing.
Yeah, that's a big one. I mean, there's a reason you're not allowed to have spouses on the board. Like, you can't have two people in the same houses on the board. There's a reason for that. So,
Right, or on a violations committee.
right,
All of
exactly,
that needs to be separated.
exactly.
Another question before you move on, do we have to share complete financial reports on our community website?
So, yes and no. And the reason why I say that is because a lot of times you get financials, you'll have two different ones, right? You'll have one that's for the residents, which may be the numbers, like this is an expense report, and then you may have a much meatier financial report, where you get every month from your accounting office, which would typically include the bank statements, copy of invoices, copies of checks. And I can understand not wanting to have every owner to have access to the banks for the association. I get that. With that being said, does it have to be on the website? The state just requires that financial reports. So how strict you want to be, it's up to you and your board and your attorney to see if this is going to be compliant or not. But in my experience, there's been that you still have them. Do owners have a right to view it? Absolutely. It doesn't have to be on the website, right? But if somebody comes to you and say, hey, I want to see like the full financials, you do have to provide it. So that's kind of how we've always handled it in the past, where we've had the one, what's on the website is going to be the expense sheets. So they kind of see the just what's being spent and how it compares to the budget. And then the much more detailed expense, financial statements, that's kind of for the board. That's available upon request. And you don't even have to tell people available upon request. But you should have it. Doesn't have to be on the website, not in my experience, but definitely
But that's the whole purpose of that new website, right? So if you give owners access through a login and a password that Vinteum can help them with, then they should be having less work to do, and management should have less work to do if all of the documents are private on a website and only the owners can access.
Yeah, that's another good point. You could have it password protected if you want to have this very strict, like if you want to have the very expensive financial report, you can have that portion password protected, and then people have to have the password to get into it, and then you have one side of it where maybe for realtors, if somebody has a realtor, they need to submit,
Right.
or for
So
lenders.
you would put the generic
Mhm.
information that the general public would need available to anyone, and
Mhm.
then the true association specific minutes, financials, contracts would be then available on the logged in side.
Yeah, the password protected side.
Right. So another question, what happens when the previous board refuses to transfer any and all documentation?
Oh, well, you have to get the pitchforks. That's the only that's the only way. I'm just kidding. I mean, that happens too, right? Where they're just not giving anything. I mean, again, take it to your attorney. I mean, send a very strong worded demand letter. Be sure you know what you're asking for. Be very specific, be very clear with what you're asking for. Because if you're just going to say, we want all emails, they're just going to say, we did give you all of them, you know? So, and then again, how much resources do you want to put into this? So be very specific, be very clear with that demand letter, if that's what's going to happen. So that would probably be the next best step. If they're ignoring letters from the manager, they're ignoring letters from the board, you take it to your attorney.
So, okay, next question. So we can put late receivables on HOA dues on our website. Not a good practice.
Yeah, I mean, definitely password protected, you know, I mean,
But still should, even if it's password protected, that's probably something I would say shouldn't be visible, because what if it's the association that made a bookkeeping error and that unit owner isn't truly late?
well, that's what I was gonna say. I've seen it where people have like because part of your financials is your delinquency report, right? Your aging report. So that'll be included like on on the email. Like that'll be included on the website, like their delinquencies, that's part of your financial report. But I mean, I don't know. I wouldn't put it like, you don't want to like publicly humiliate people, right? And be like, this month this
Right.
guy's late. Like I would not do that at all.
Exactly. Not a good practice.
Not a good practice. Peggy, another question.
Yeah, just to comment on that is the also responsibility that's kind of unsaid of the board is to help the community be harmonious, and that does not foster good relationships amongst the community residents. And if somebody asks, you have to divulge it, but to make it public information like you're putting the scarlet letter on them is not going to promote harmonious anything. So just keep that in mind always as your congenial responsibility to your community.
Yeah, there's enough headaches already. You do not want to have headaches with your neighbors. That's just too much drama. That's a drama that's notorious, but we could change that, folks. You're new to the board. You're bringing a fresh energy to it. We could change the dynamic. And the associations are notorious for the drama. Or maybe I should say maybe they're not. I'm gonna start saying differently, right? They're not. They're known for being very well ran, happy people. Let's make that the new norm.
Another question, if there
Yeah.
is one opening due to a resignation on the board and two people want the spot, how should the board properly decide which candidate?
Well, it's up to you guys. I mean, if you want to flip a coin, flip a coin. If you want to, rock, paper, scissors, if you want to just leave it vacant, you can. It's up to you how you decide. And then of
Right,
course,
they could take both, assign somebody to a committee.
yeah.
At a committee, they could wait till the next election and let the unit owners decide.
Yeah, I mean, if you have too many volunteers, in a way, that's a good thing. Most people can't find anybody to volunteer for their board. So if you're in a situation where you have people who want to actively help the association, help the board, that's a great opportunity. At the end of the day, these are all just titles. Everybody's one thing though that everybody shares is everyone wants to see the association succeed. And they want to, foster a happy community. That's pretty universal. So if you have a situation like that, put one as a director, put one on the committee, put them both as a committee, as a committee members, it's have them wait, but I think that would be a great idea.
Okay, more questions. Can Zoom meeting recordings replace meeting minutes, or AI companion needed speech to text?
It can, because meeting minutes are just records of your meeting minutes are just records of your meeting, right? So if you're recording like the motions, that's fine, but I would be very careful about documenting everything that's being said and putting that as your meeting minutes. That's not a best practice at all, because sometimes typically your meeting minutes are just for motions. The board voted on this, it was unanimous. The owner voted on this, it was unanimous, it was contested. That's typically what you're recording in your meeting minutes. If you get into the practice of recording dialogue, now you're including, now you're including conversations. What's going to happen one day is somebody is going to pull these meeting minutes and say, hey, look, on this date, you said this, and they're going to nitpick that apart. And that could easily open your association for liability that you may not want. So can it be done? Yes, if you're recording the motions, but, be very careful about what you're putting in your meeting minutes.
Right. Those Zoom meetings and AI companion can be used to help record the minutes, and then the minutes should be paper and, to your point, short, only about motions. But the technology can certainly be used to assist writing them.
Yeah.
Can a property management website for our community be sufficient to house this documentation, or must it be an association website?
It could be the management company. The management company can provide it. You log into the management website, and then, once you log in, it has the information for that association. That's fine. The statute doesn't say you have to have your own domain. It just says you have to have a website. So Vinteum could speak on this if they want, but they have, things that are very generic, but then they also have ones that are very like generic in the sense that it'll be like Vinteum / Limestone Association. But then there's also ones where you could have very tailored websites. So it'd just be limestoneassociation.org, and then you have everything about the association. So it's however.
Right. And it's probably a good practice to keep your association records website separate, because what if you no longer use that management company? Then you're starting all over, recreating everything that existed. That management company is not going to hand you that product.
Yeah, they're going to hand you the files, and now you're going to have to go through it again and make sure everything is put in the right folder in the right spot on the website, versus if you had the and again, best practice for the association, versus if the association was managing the website themselves, or it wasn't through the management company, then great, you just one less thing to worry about if you do have to change manager for any reason. Now, the management company can maintain the website, that's no problem,
Correct.
but.
Right, you can provide them the login and
Yeah.
access, but best practice would probably be having it your own website. That law is not going to change. If anything, it'll just get enhanced because transparency in associations is so important, right?
Yeah, exactly. That's the whole name of the game. Like I said, glass house. So everybody sees through the walls, you see through everything. So it'll just get more transparent as time goes on. I doubt they'll start redacting more and more.
Right. If a board member was removed for unethical behavior, how long can they be banned?
We talk about that. I think maybe in the next one we're gonna talk about what like when or maybe in this chapter, when somebody is could be removed from their board, what require them to be removed. Ethics is I gotta tell you, I don't know ethically what it, like, if there is anything to be banned per se. I know if somebody committed fraud or financial crime, they're barred from being on their board of directors. But if they violate some kind of ethics, let's say a realtor by the ethics, or then I don't know if that necessarily bans them from the board. Doesn't look good, that's for sure, but it doesn't necessarily legally from from that standpoint ban them from being on it. Sounds like a good question for your attorney, I can tell you that. But that's a tough one.
Another question, sorry. There's a flurry going on in the chat, and that makes it a little difficult to track for the questions.
Yeah, we used to just have the Q&A, so maybe next time we'll just stick with questions and not have a chat, because I see 99 messages. My goodness.
Yes, and it's very difficult because you read something and then there's 4 more things that have nothing to do with the original. So
Yeah.
I'm going to ask that if you truly put a question in the chat, that you go ahead and retype it in the Q&A so that we can properly address it. And as Peggy had indicated, these are recorded, the Q&A. The chat is not.
Yes,
So
please.
another question. If I am on the board thread of an email, do I need to keep every single response on the thread from every board member or just the final email that contains the response? For example, 3 board directors respond they agree on a vendor to use for a maintenance repair. At the end of the email thread, we can see all responses. Do I need the individual response for each board member or just the final email? Well, let's remember that motions need to be happening at board meetings, not in emails. So that's step 1.
Mhm. That's exactly what I was going to say. Yeah, you shouldn't be really having a quorum on your emails and making motions. Definitely number 1. And number 2, again, any email, but this is what we're talking about, right? If you get a records request and somebody sees this and they have their attorney looking at this and they're seeing that you're making motions via email and that you're having, private discussions that's not in front of the owners, that could be opening the association for liability. So you want to be very careful with what you're putting in writing and what you're putting in an email. And then keeping in mind your quorum. You should not be having a quorum of members discussing association business on email or even on the phone or by the pool. That's what board meetings are for.
Correct. That's the sunshine law.
There you go.
Another question, should you destroy the recording of your meetings once the minutes are approved? Yes, because otherwise those recordings become part of the association's records.
Yeah, I guess there's no requirement that you have the meeting minutes, so there's no requirement that says you have to keep your Zoom, your meeting recordings, or whatever, just your minutes, right? So
Correct.
if you as a secretary are recording the meeting, and that would probably be one of the only people who is actually recording the meeting. But if your secretary is recording and they're using that for minutes, great. Take it, make your minutes, but then get rid of the recording. Just keep the minutes. I'm going to continue on now. You have any more questions? No more questions?
Well, there are questions, but you can move on.
Okay. So continuing on, accounting records for the associations and separate accounting records for each condominium that the association operates. Any person, I think I read this one wrong. This one. So again, more definitions for what is an official records. All contracts for work to be performed, bids for work to be performed are also considered official records and must be maintained by the association for at least 1 year after receipt of the bid. Ballots, sign-in sheets, voting proxies, and all other papers and electronic records relating to voting by unit owners, which must be maintained for 1 year from the date of the election, vote, or meeting to which the document relates, notwithstanding paragraph B. All rental records if the association is acting as an agent for the rental of condominium units. A copy of the current question and answer sheet as described in statute 718. A copy of the inspection reports described in statute 553-899 and statute 718-301 4P, and any other inspection report relating to a structural or life safety inspection of condominium property. Such record must be maintained by the association for 15 years after the receipt of the report. Bids for materials, equipment, or services, all affirmative acknowledgments made pursuant to statute 718-121 4C, a copy of all building permits, a copy of all satisfactorily completed board member educational certificates, all other written records of the association not specifically included in the foregoing, which are related to the operation of the association. Section 718-111-12, the official record specified in subparagraph A 1 through 6 must be permanently maintained from the inception of the association. Bids for work to be performed or for materials, equipment, or other services must be maintained for at least 1 year after receipt of the bid. All other official records must be maintained within the state for at least 7 years, unless otherwise provided by general law. The official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner. That's a big one. The official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner. I'm just going to stop here because I mentioned earlier about how there was a time where people would just say, this is our storage of our files, go crazy, and that was okay. But now, and record, this is why records, and by another reason, just to go electronic, right? Like minimize paper, put everything on the website, you know, so that way you're compliant with the law. Because if you're just doing things by the paper still, by paper, and it's not, you just have it shoved in a filing cabinet. I've seen storage closets filled with paperwork from the moment the association was created in the 70s to today. So they have bids and old financial statements from like the 90s and 80s, whatever it may be. That's the time where you got to call probably a professional company. You have a board member, call somebody like Iron Mountain, call a manager, call your attorney, somebody, and you're going to have to start getting rid of and some of that old paperwork if it's past the statute of requirement of when you need to have it. If it's older than 7 years, older than 15 years for inspection reports. If it's, you know, if it's more than a year from the bid, start getting rid of stuff. So that way you could be in compliance with the state, because it has to be stored in a way and organized in a way to facilitate inspection. In the event that the official records are lost, destroyed, or otherwise unavailable, the obligation to maintain the official records includes a good faith obligation to obtain and recover those records as is reasonably possible. And then again, records must be maintained in an organized manner that facilitates inspection. Section 718-111-12. The records of the association shall be made available to the unit owner within 45 miles of the condominium property, or within the county in which the condominium property is located within 10 working days after receipt of a written request by the board or its designee. By the way, there's some potential where they're going to be shortening this 45-mile requirement. Not signed to law, keep an eye for that. However, such distant requirement does not apply to an association governing a timeshare condominium. This paragraph and paragraph C may be complied with by having a copy of the official records of the association available for inspection, or copying on the condominium property or association property. Or the association may offer the option of making the records available to a unit owner electronically via the internet as provided under paragraph G, or by allowing the records to be viewed in electronic format on a computer screen. An association member or his or her authorized representative in compliance with this chapter, unless the association has an affirmative duty not to disclose such information under this chapter. The association must make records available within 10 working days after receipt of a request. So that's working days. Typically it does not include Saturday, Sundays. Unless you're working those days, your office is open, then it would include those days. If not, typically Saturday, Sunday is not included. Again, it's pretty lenient on how to inspect the records, right? If somebody wants to look at it on a screen, that's an inspection. Somebody wants to come with a phone, take pictures, that's an inspection. If it's on a website, they can inspect it on the website, but you have to give it to them. That's the important thing too. The official records of the association are open to inspection by any association member or any person authorized by an association member as a representative of such member at all reasonable times. The right to inspect the records includes the right to make or obtain copies at the reasonable expense, if any, of the member and of the person authorized by the association member as a representative of such member. A renter of a unit has a right to inspect and copy only the declaration of condominium, the association's bylaws and rules, and the inspection reports described in statutes 553-899 and 718-301 for repeat. The association may adopt reasonable rules regarding the frequency, time, location, notice, and manner of record inspections and copying, but may not require a member to demonstrate any purpose or state any reason for the inspection, which is, in my experience, sometimes contentious, which again, doesn't have to be. People have a right to view what the association is doing, view all those items that were listed before. It was like 30 or 40 items. And they don't have to tell you why. They could do it at any time. All the more reason to be very careful about what you put in writing. Be very careful what you put in the meeting minutes, and be very mindful about what it is that's happening on these recordings if you go that route too, which I said, not the best opportunity, but not the best choice, that you can do that too. Penalties for failing to produce records. The failure of an association to provide the records within 10 working days after receipt of a written request creates a rebuttable presumption that the association willfully failed to comply with this paragraph. The unit owner who is denied access to official records is entitled to the actual damages or minimum damages for the association's willful failure to comply. Minimum damages are $50 per calendar day for up to 10 days, beginning on the 11th working day after receipt of the request. The failure to permit inspection entitles any person prevailing in an enforcement action to recover reasonable attorney fees from the person in control of the records who directly or indirectly knowingly denied access to the records. If the requested records are posted on the association's website or are available for download through an application on a mobile device, the association may fulfill its obligations under this paragraph by directing to the website or the application all persons authorized to request access. So again, all the more reason to have a good website. There are website requirements. Not every association needs to have a website. I believe if it's under like 25 units, you don't have to have a website. If you make less than $300,000 a year, you don't have to have a website, if I recall correctly. But it helps for situations just like this. And quite honestly, we live in a time where a website is very nominal in fee. It's not a whole lot of money. Vinteum, again, could speak on that. I've been plugging them so much. You're welcome. But but it's not a whole lot to have a website, to build it, to maintain it. It might cost you a couple $100 a year, and you are compliant. You don't have to deal with these requests. Go to the website. It's truly, again, one of those things that would be up there in best practices.
Thanks, Brian, for all the mentions.
You're
Brian
welcome.
and Jamie, we're very happy and glad about that. And you're right. One of the things that website is such an easy thing for us to do and to provide to the communities. Besides all the other features that we do have, that we make sure that all of our app is compliant to the general rules, and mainly for Florida rules as well. Of course, you have to double check that with your lawyer. We can speak on behalf of them, but our features are mainly based thinking about these different laws, including different states as well. Thanks so much for the heads up.
You're very welcome.
Brian, before you move on, clarification, does an email request for written records qualify?
Absolutely. If somebody's sending you an email that I want to see, the records request, you should honor that. Now it does say, and I will say this, it does say, I think I passed it, but it mentioned how the state mentioned how the association could enact rules in managing these sort of requests. So if, let's say, you wanted to pass a rule that say any records request must be sent via USPS, any records request, we can only get one records request per year. You could enact reasonable rules. Again, you may want to ask your attorney again what rules these could be. They would like to see you do, but you can pass rules to help manage these sort of requests, because I can understand you don't want to have, and I've been in that situation, where you get bombarded with records requests because now there's some rumor that's going on, and then you have those people who want to, I'm not saying want to, but you'll have a small group who just, they're now sending all these emails, and you can't do anything until you enact some rules about this. So now you're going to change it to where people, if you're going to put in record requests, it has to come in through the mail, has to come first class mail, and then you can only do one per year. So it's definitely possible, but get with your attorney to talk about trying to enforce and what kind of framework you'll need in order to get that approved.
Right. So that same individual then responded to say that their attorney has said that all owner inquiries should be by certified written request. So that's exactly what you just said.
And there you go. So you can't take an email, certified written request. Inspection checklist. Now, this is what I mentioned before, and it's about how there was a time where you could tell someone, hey, knock yourself out, here are the records. Now you have an inspection checklist. In response to a written request to inspect records, the association must simultaneously provide to the requester a checklist of all records made available for inspection and copying. The checklist must also identify any of the association's official records that were not made available to the requester. An association must maintain a checklist provided under this subparagraph 4. There goes again, 7 years. They like 7, I'm telling you. An association delivering a checklist pursuant to this subparagraph creates a rebuttable presumption that the association has complied with this paragraph. So you got to give them a checklist. What we're giving you here, John Doe, you ask for the financials, you ask for, unit owner records, you ask for, files for these people, you ask for this. We're giving you this, and this. We cannot give you 1, 2, 3, and here's why. A director, penalties for repeated offenses. A director or member of the board or association or community association manager who knowingly, willfully, and repeatedly violates subparagraph 1 commits a misdemeanor of the 2nd degree, punishable as provided in statute 775.082 or statute 775.083, and must be removed from office in a vacancy declared. For purpose of this subparagraph, the term repeatedly means 2 or more violations within a 12-month period. Now you're committing a 2nd degree misdemeanor. Now, I'm not an attorney. I don't know what that means, how much jail time or fine. But I'll tell you what, it doesn't sound good. If you're creating a 2nd degree misdemeanor, it does not sound good. Penalties for repeated offenses continued. Queen Peggy, she has a question. Go ahead.
I
Or
just
comment.
want to say, I think it means you can't be on the board. Correct, Jamie?
I'm sorry, I was answering a question. What was the question?
If you have a misdemeanor, 2nd degree misdemeanor violation because you didn't provide something, records or transparency records for a resident, and you get all the way to the point where you have a 2nd degree misdemeanor, you can't be on the board anymore, can you? You have
Correct.
okay. So that's very important.
I'm
You're
asking.
removed from the board.
Yeah, in Florida, I just did a quick Google search. In Florida, a 2nd degree misdemeanor is not only can you not be on the board, but it is a criminal offense. It's lower penalties, but it is a criminal offense. So that could be up to 60 days in jail, 6 months of probation, and a fine up to $500. Imagine sitting in a jail cell and somebody said, why? Well, I deleted some association records. I tell you,
Not worth it.
not worth it at all.
It could even affect, if you're still working, your
Yeah.
employer,
Oh yeah.
you know?
Yeah.
That's very serious. Okay.
Very
Thanks.
serious. So continue on. Section 718, 111, 12. Any person who knowingly or intentionally defaces or destroys accounting records that are required by this chapter to be maintained during the period for which such records are required to be maintained, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created or maintained with the intent of causing harm to the association or one or more of its members, commits a misdemeanor of the first degree, punishable as provided in statute 775.082 or statute 775.083, is personally subject to a civil penalty pursuant to statute 718 501 1D, and must be removed from office and a vacancy declared. So again, it would say commits a misdemeanor, first degree misdemeanor. Now it's civil penalty. So this is serious. You know, this could change your life depending on how you run the associations. Now, this is not to scare anyone. I don't want you leaving here like, oh God, I'm going to jail. Like, that's not the whole point of this. The point is just to, again, if you're it's fairly simple. Again, there's no rules, not rules, no law, not no laws, no secrets. It's a glass house. If you're maintaining your website, you're putting things, you know, what has to be up there, that needs to be up there, proposals, bids, contracts, invoices, financial reports, meeting minutes, meeting agendas. You're putting that stuff up there, great. If you're willfully not doing it, I'm not going to do it. You know, they could kick rocks. It could be a real problem.
I have a question on that before you move on. Can a board force a community to get into contracts with cable internet providers without a community vote?
Can boards force community members?
Can a board force a community to be entered into a contract for a cable internet provider without a community vote?
I mean, it depends, but I'd say typically if let's say your board of directors say we have Comcast, we want to get rid of Comcast and we want to bring in AT&T, they could do that. You know, they're working on behalf of the owners. Of course, it's always good to get input from owners so that way you could, you know, so that way they're not just making the decision based off of what they feel is best. That's the whole point of being a board of director. You have to work on behalf of your owners. But is that something that goes to the vote of the membership? That's not something that I've seen that gets done.
In any case, that any contract should be sent to the association's attorney for review and never execute a long-term contract or any contract that the attorney hasn't reviewed. And at the same time, the attorney would advise based on knowing the declaration of the association, whether a vote would be required or not.
Mm-hmm. Very good point too. Always have your attorney review contracts, especially for the and those cable contracts, because a lot of these because when these cable companies come into the property, they're investing a lot on their side as well. They're running a lot of cable, they're hiring manpower, so a lot of them are very like long and they're tough to get out of. Yeah, I cannot say more than enough. Have your attorney, you know, review it and make sure that the attorney gives it the stamp of approval. And same thing, even for the previous one, it should have been done so that way, you know, if you are transferring, there's no, you know, there's no recourse from the association for making that transfer. But I mean, long story short, I guess to answer their question, can they? Yes, but there are so many other variables. Get with their attorney, and they'll be able to assist a lot better because there's so many details to these. Or get with your manager.
Right. So to clarify her question, because she's come back with two additional comments, we don't currently have a contract for each unit. And then she said, not my question. The contract would be to provide each unit to have cable and phone. And that would, in my opinion, make sense. Each unit would be provided cable and phone if the association was entering into a bulk contract. And same answer still prevails. The association's attorney should be reviewing the contract that the association is entering into and verifying that it meets statute and requirements of the declaration. And yes, they could have a contract that goes into your unit to give you cable and phone. Even if you personally don't want to participate, you're still being provided that service, and it would still be provided as part of your budget. You wouldn't be able to remove yourself from it.
Yeah, remember that if you look in your docs, there are easements inside the buildings, inside the units, and the easements are paths basically that the association has right to, and they have right to access or right to do with what they feel is best. So bulk contracts are very common. Yeah, they could do that. They definitely can do that. Any more questions?
Not related to this, no.
All right. We're gonna go
Yes, I
on.
have more. Yes, I have more questions, but we'll get.
I know, I can see that. A lot of questions, but it's good. It's making this more fun.
Right, more interactive makes it
Yeah.
relatable to the participants instead of just, we could have just hand out the flyer, the presentation. But this way, with questions, someone may think of something, and plus for your experience, my experience, Peggy's experience, I think it's helpful.
Oh yeah. It definitely is. So a person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape, commits a felony of the third degree, punishable as provided in Statute 775.082, Statute 775.83, or Statute 775.84, and must be removed from office and a vacancy declared. So now we're getting into a third degree felony. I mean, that's heavy stuff. Right to inspect records. The association shall maintain an adequate number of copies of the declaration, articles of incorporation, bylaws and rules, and all amendments to each of the foregoing, as well as the question and answer sheet as described in Statute 718-504, and year-end financial information required under this section on the condominium property to ensure their availability to unit owners and prospective purchasers, and may charge its actual cost for preparing and furnishing these documents to those requesting the documents. An association shall allow a member or his or her authorized representative to use a portable device, including a smartphone, tablet, portable scanner, or any other technology records in lieu of the association's, providing the member or his or her authorized representative with a copy of such record. The association may not charge a member or his or her authorized representative for the use of a portable device. Notwithstanding this paragraph, the following records are not accessible to unit owners. So portable device, typically camera or phone, they could take photos. Any record
Before you move on, I just want to make a comment on the records. If you would go back on the slide where it says that keep an adequate number of copies of the declaration, articles, bylaws, etc. To clarify that, it is the recorded copies of those items. I can't tell you how many times I can get a loan request, most likely from a self-managed association, and they just send me a copy of a declaration, and I have to send it back to them and explain to them, you have to go to, if you don't have the recorded copy, you should be going to the county's website and get a copy of all of the recorded documents, because those are the only ones that count.
Yep. Any record protected by the lawyer-client. Okay, so these are records that are not accessible to unit owners. Protected record. Any record protected by the lawyer-client privilege as described in Statute 90-502, and any record protected by the work product privilege, including a record prepared by an association attorney or prepared at the attorney's expense direction, which reflects a mental impression, conclusion, litigation strategy, or legal theory of the attorney or the association, and which was prepared exclusively for civil or criminal litigation or for adversarial administrative proceedings, or which was prepared in anticipation of such litigation or proceedings until the conclusion of the litigation or proceedings. Information obtained by an association in connection with the approval of the lease, sale, or other transfer of a unit. C. Personal records of association or management company employees, including but not limited to disciplinary, payroll, health, and insurance records. For purpose of this subparagraph, the term personnel records does not include written employment agreements with an association employee or management company, or budgetary or financial records that indicate the compensation paid to an association employee. Any record protected by the lawyer-client privilege as 9502, and any record protected by the work product. Let's do that. There you go. Medical records of unit owners, social security numbers, driver's license numbers, credit card numbers, email addresses, telephone numbers, facsimile numbers, fax numbers, emergency contact information, addresses of a unit owner other than as provided to fulfill the association's notice requirements, and other personal identifying information of any person, excluding the person's name, unit, designation, mailing address, property address, and any address, email address, or facsimile number provided to the association to fulfill the association's notice requirements. Notwithstanding the restriction in this subparagraph, an association may print and distribute to unit owners a directory containing the name, unit address, and all telephone numbers of each unit owner. However, an owner may exclude his or her telephone numbers from the directory by so requesting in writing to the association. An owner may consent in writing to the disclosure of other contact information described in this subparagraph. The association is not liable for the inadvertent disclosure of information that is protected under this subparagraph if the information is included in an official record of the association and is voluntarily provided by an owner and not requested by the association. More records that are protected. Electronic security measures that are used by the association to safeguard data, including passwords. The software and operating system used by the association, which allow the manipulation of data, even if the owner owns a copy of the same software used by the association. The data is part of the official records of the association. All affirmative acknowledgments made pursuant to Statute 718, 121, 4C. The Q&A sheet. The association shall prepare a question and answer sheet as described in Statute 718, 504, and shall update it annually. The association or its authorized agent is not required to provide a prospective purchaser or lien holder with information about the condominium or the association other than information or documents required by this chapter to be made available or disclosed. The association or its authorized agent may charge a reasonable fee to the prospective purchaser, lien holder, or the current unit owner for providing good faith responses to requests for information by or on behalf of a prospective purchaser or lien holder, other than that required by law, if the fee does not exceed $150, plus the reasonable cost of photocopying and any attorney's fees incurred by the association in connection with the response. An association and its authorized agent are not liable for providing such information in good faith pursuant to a written request if the person providing the information includes a written statement in substantially the following form. The responses herein are made in good faith and to the best of my ability as to their accuracy. Managing your website. I'm going through this because we're down to about an hour and a half or so. By January 1st, 2019, an association managing a condominium with 150 or more units, which does not contain timeshare units, shall post digital copies of the documents specified in paragraph 2 on its website, or make such documents available through an application that can be downloaded on a mobile device. The association's website or application must be an independent website, application, or web portal wholly owned and operated by the association, or A website application or web portal operated by a third-party provider with whom the association owns, leases, rents, or otherwise obtains the right to operate a web page, subpage, web portal, collection of subpages or web portals, or an application which is dedicated to the association's activities and on which required notices, records, and documents may be posted or made available by the association. So that answers the question that somebody asked earlier about whether or not they need to have their own portal, like their own website, or can the management, provide that through their website. You can. It could be a web portal, it could be an application, it could be something, but it does have to have their information and make sure that's compliant if you are going to go that route. The association's website or application must be accessible through the internet and must contain a subpage, web portal, or other protected electronic location that is inaccessible to the general public and accessible only to unit owners and employees of the association. Upon a unit owner's written request, the association must provide the unit owner with a username and password and access to the protected sections of the association's website or application, which contain any notices, records, or documents that must be electronically provided. A current copy of the following documents must be posted in digital format on the association's website or application. The recorded declaration of the condominium of each condominium operated by the association and each amendment to each declaration, the recorded bylaws of the association and each amendment to the bylaws, the articles of incorporation of the association or other documents creating the association, and each amendment to the articles of incorporation or other documents. The copy posted pursuant to this subparagraph must be a copy of the articles of incorporation filed with the Department of State. The rules of the association. And just going to say that's exactly what Jamie was just saying as well. It has to be a copy that is filed. So you have to have, if you're gonna post your article of incorporation, your declaration, amendments, you have to have the ones that have been filed with the state. That's what makes them official. Managing your website continued. A list of all executory contracts or documents to which the association is a party or under which the association or the unit owners have an obligation or responsibility, and after bidding for the related materials, equipment, or services has closed, a list of bids received by the association within the past year. Summaries of bids for materials, equipment, or services which exceed $500 must be maintained on the website or application for 1 year. In lieu of summaries, complete copies of the bids may be posted. I would say it's very common. Most people just put a copy of the bids. Summary, that's just more work for yourself. Why summarize it and just put it up there? The annual budget required by statute 718-112-2F and any proposed budget to be considered at the annual meeting. The financial report required by subsection 13 and any monthly income or expense statement to be considered at a meeting. Continuing on, the certification of each director required by statute 718-112-2D4B. All contracts or transactions between the association and any director, officer, corporation, firm, or association that is not an affiliated condominium association or any other entity in which an association director is also a director or officer and financially interested. Any contract or document regarding a conflict of interest or possible conflict of interest as provided in statutes 468, 430, 4335, 468.436 2B6, and 718.30227, subsection 3. The notice of any unit owner meeting and the agenda for the meeting as required by statute 718-112-2D3, no later than 14 days before the meeting. The notice must be posted in plain view on the front page of the website or application, or on a separate subpage of the website or application labeled notices, which is conspicuously visible and leaked from the front page. The association must post on its website or application any document to be considered and voted on by the owners during the meeting or any document listed on the agenda at least 7 days before the meeting at which the document or the information within the document will be considered. Notice of any board meeting, the agenda, and other document required for the meeting as required by statute 718, 112(2)C, which must be posted no later than the date required for notice under statute 718, 112(2)C. The inspection report described in statute 553, 899, and 718, 301, 4P, and any other inspection report relating to a structural or life safety inspection of condominium property. The association's most recent structural integrity reserve study, if applicable, copies of all building permits issued for ongoing or planned construction. Now, when I read this, I still think about it too. It's like, it says here, the notice of any unit owner meeting and the agenda for the meeting as required by statute 718, no later than 14 days before the meeting. So again, don't just think when you're sending out your notices for the meeting, you should simultaneously be posting them on your website. Annual meeting notices, budget meeting notices, those also have to go on your website within that time limit. So you can't just post it 48 hours in advance. You have to post, your first notice 60 days before, 60 days in advance, it should be on your website. And then it also mentioned it has to be accessible from the front page. If it's not on the front page, you could have it in another section labeled notices. But again, it should also be accessible from the front page. So very convenient, big letters. It says right here, conspicuously visible and linked from the front page. So you can't have notices on the bottom and small writings. You have big letters. This is where your notices are. This is where the board meeting is going to be held. Again, this is all about transparency for owners. We're harboring a good environment for people as well. Any comments, Jamie?
Do renters have access to an association's website?
I believe it said they have access to like the declaration, right? So typically and I've seen that too, where you will have another section of the website just for renters. So it might have the rules, it might have the declaration, but it wouldn't have anything, that owners would have access to, like the financials or the meeting minutes or the board agendas, that kind of stuff. Renters don't need to see that. Document accessibility. The association shall ensure that the information and records described in paragraph C, which are not allowed to be accessible to unit owners, are not posted on the association's website or application. If protected information or information restricted from being accessible to unit owners is included in documents that are required to be posted on the association's website or application, the association shall ensure that the information is redacted before posting the documents. Notwithstanding the foregoing, the association or its agent is not liable for disclosing information that is protected or restricted under this paragraph unless such disclosure was made with a knowing or intentional disregard of the protected or restricted nature of such information. The failure of the association to post information required under subparagraph 2 is not in it of itself sufficient to invalidate any action or decision of the association's boards or its committee. Obligations of owners and occupants, in addition to remedies. The association may levy reasonable fines for the failure of the owner of the unit or its occupant, licensee, or invitee to comply with any provision of the declaration, the association bylaws, or reasonable rules of the association. A fine may not become a lien against a unit. A fine may be levied by the board on the basis of each day of a continuing violation with a single notice and an opportunity for hearing before a committee as provided in paragraph B. However, the fine may not exceed $100 per violation or $1,000 in aggregate. An association may suspend for a reasonable period of time the right of a unit owner or a unit owner's tenant, guest, or invitee to use the common elements, common facilities, or any other association property for failure to comply with any provision of the declaration, the association bylaws, or reasonable rules of the association. This paragraph does not apply to limited common elements intended to be used only by that unit. Common elements needed to access the unit, utility services provided to the unit, parking spaces, or elevators. So what time is it now? 11:36. And I believe this is our last break time. And then we're going on to our final module, bids and contracts.
Peggy, I have a housekeeping item before we go to break if you're there.
Trying.
Okay,
here.
I have a few people that have had to switch devices or lost connection for a few minutes, and they're concerned that they're going to get the proper credit for the class.
As long as you re-log on within a few minutes, we can add all the email time and phone time together because we have a record of all of it, but you have to do it, you know, within a timely fashion. It can't be 2 hours later or 1 hour later. It has to be within a few seconds or minutes, I'm sorry.
And if they had to change devices,
Well, it either has to be your phone or your laptop, whichever information you put on the registration, that is the only matchup. If it's anything else, it's not logged in as a registration, then it will not be counted. In other words, if you have a laptop, you switch to a different laptop, but you use the same email, it will be okay. If you switch devices, computer, phone, whatever, and use a different email, it will not be counted. If you have your phone registered and your laptop registered, or your iPad, whatever email place, it's not where you're from, it's using the email and the same phone number that you registered with.
perfect. Thank you.
You're welcome.
Any questions? No? Yes? Maybe? Or maybe we'll answer them when we come back. This is our last chapter, so. The next one
How
is,
long?
go ahead.
I was going to say, how long is the break?
Well, we're making decent time, so I'm thinking this one, let's make it a 10-minute break. We'll be back at, right now it's 11:38, so let's be back at 11:40. And we'll
No, that's 2 minutes.
Oh, I'm sorry, 11:50. 11:50. Break's over. All right, guys, we're back.
Break's over, but I do like your frogs.
I know, I saw them and I'm like, they're so cute. I gotta put them.
They are. That's how I feel like I need a stretch.
That's you and me.
Yep. All right. See you at 11:50.
11:50, folks. All right, I'm back. I wish we could look at the frogs this whole time, but we can't keep looking at the frogs. We're gonna get right to it. Let's finish strong. Bids and contracts. Oh, well, let me start because we do still have some time. Are there any other questions or anything you think we could go over before getting into a news topic?
No, because most of them relate to contracts.
Okay, very good. Contracts for products and services in writing bids exceptions. Associations with 10 or fewer units may opt out of the provisions of this section if 2/3 of the unit owners vote to do so, which opt-out may be accomplished by a proxy specifically setting forth the exception for this section. Bid, Section 718, 3026, 1. All contracts as further described herein, or any contract that is not to be fully performed within 1 year after the making thereof for the purchase, lease, or renting of materials or equipment to be used by the association in accomplishing its purposes under this chapter, and all contracts for the provision of the services shall be in writing. That means no verbal contracts. If a contract for the purchase, lease, or renting of materials or equipment or for the provision of services requires payment by the association on behalf of any condominium operated by the association in the aggregate that exceeds 5% of the total annual budget of the association, including reserves, the association shall obtain competitive bids for the materials, equipment, or services. Notwithstanding contained herein shall be construed to require the association to accept the lowest bid. Also, two very common things that I've seen where board members feel that they have a legal obligation to go to the lowest bidder, or they have a legal obligation to get 3 bids. You do not, as it says right here, unless 5% of the total annual budget, including reserves. So that's typically, in my experience, that's a pretty high threshold. A lot of associations, just for their own, let's say, best practice, they may get 3 bids if it exceeds 5,000. Just so that way things don't get bottled up too long with just getting bids. And then, of course, it doesn't mean you have to go with the lowest bid. Sometimes you're going to go with somebody who may be even, if not the high, maybe not the highest. I haven't seen that, but you may go with somebody who's kind of in the middle. They're not the cheapest, but they're not the most expensive. That's perfectly fine. Notwithstanding the foregoing, contracts with employees of the association and contracts for attorney, accountant, architect, community association manager, timeshare management firm, engineering, and landscape architect services are not subject to the provisions of this section. Nothing contained herein is intended to limit the ability of an association to obtain needed products and services in an emergency. This section shall not apply if the business entity with the association desires to enter into a contract is the only source of supply with the county serving the association. Nothing contained herein shall excuse a party contracting to provide maintenance or management services for compliance with statute 718, 3025. This is a good one, conflicts of interest. Directors and officers of a board of an association that is not a timeshare condominium association and the relatives of such directors and officers must disclose to the board any activity that may reasonably be construed to be a conflict of interest. A rebuttable presumption of a conflict of interest exists if any of the following occurs without prior notice, as required in subsection F. A director or an officer or a relative of a director or an officer enters into a contract for goods or services with the association. A director or an officer or a relative of a director or an officer holds an interest in a corporation, limited corporation, partnership, limited liability partnership, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. and then how to handle a potential conflict of interest. If a director or an officer or a relative of a director, and I'm going to read this and then I'll probably ask you if you have any questions, because I always get questions on this section, but this paragraph might answer them already. So if a director or an officer or a relative of a director or an officer proposes to engage in an activity that is a conflict of interest as described in subsection 1, the proposed activity must be listed on, and all contracts and transactional documents related to the proposed activity must be attached to the meeting agenda. The association shall comply with the requirements of statute 617.0832 and the disclosures required by statute 617.0832 shall be entered into the written minutes of the meeting. Approval of the contract or other transaction requires an affirmative vote of 2/3 of all other directors present at the next regular or special meeting of the members. The existence of the contract or other transaction shall be disclosed to the members. Upon motion of any member, the contract or transaction shall be brought up for a vote and may be canceled by a majority vote of the members present. If the contract is canceled, the association is only liable for the reasonable value of the goods and services provided up to the time of cancellation and is not liable for any termination fee, liquidated damages, or other form of penalty for such cancellation. So any questions? How are we doing?
No questions. At least not on that.
Interesting.
Also
Okay.
to mention, you have until 2 p.m.
Till 2? We
I'm
started at
sorry,
No.
1 p.m.
4 hours is 1, Peggy.
Yeah.
Yeah, I'm sorry.
Yeah. You got me nervous. I was like, we are way off schedule. Yeah, so we have about I still have a few more slides. We're almost at the top of the hour, so keep an eye on those questions. The association shall comply. But I bring this up because conflict, like, there are times where people say there's a conflict of interest, so we can't use it, right? Let's say somebody's spouse owns a landscaping business, they need a landscaper. Well, we can't do it. Even though that is a conflict of interest, of course, to having, let's say, a board member who has a landscaping business also do the landscaping. There are ways to approve this person, which is why I like this section, because it so clearly says what you need to do if there is a conflict of interest. Bring it up to the membership, bring it up to the owners, get a vote on it, disclose it at the meeting, put it in the meeting agenda, put the bid as part of the meeting agenda. Again, transparency is the goal. So I can't think of anything more transparent than how they're saying to do it, which is great. So don't get the other thing I'd say is, even though some people like to sometimes it can be framed as something that's negative, which is very common and easy for us to do. There's a plus side of having, let's say, in the scenario that I used, a board member who also owns a landscaping company that's just closed, whatever it may be. A lot of times you get a deal for that because they live there, right? So they want to make sure that the association is not overspending as well. So there may be a little bit more wiggle room versus somebody who has to, drive and out of their way to do your landscaping. So there's some pluses to it. And I'm not advocating for either side. That's not what I'm doing. I'm just saying that you can proceed, although carefully, but you still can proceed. And that's very good.
And it's also a good practice that board member recuse himself from the vote.
Oh, yes. Yes. And I think we get in that here too. But when they vote, don't recuse himself. Imagine they get a vote on whether or not to prove their own company.
Yeah, not a good idea.
Not a good idea. But I have seen I've been asked that before, they're like, do I get a vote? And it's like, no, you don't. And in fact, and I believe we're going to cover in one of these slides, they're supposed to even leave the room when you're voting and discussing their contract, and then they come in afterward because you don't want them, influencing. And I mean, it's kind of a no-brainer. You wouldn't want them there while you're voting on it and discussing on it. Just keep them out of the picture as much as possible.
But to your point, as long as the process was properly bid and that is a viable option for a vendor, a lot of times when I was a manager, they were good vendors because they live there. They wanted to make sure that the property is well maintained.
Yeah, exactly. So there's pluses to it. So like I said, they explain it very well. Oh, why did it? Okay, yeah. Now it does say, I want to point out, or if you do cancel, let's say they cancel it, right? It says you're only liable for the reasonable value of the goods and services provided up to the time of cancellation. So that's, again, I think also very good, because I know there's been cases where, I'm not talking about legal cases, but like instances where people get upset and bitter, naturally so. You just canceled their company, so now they're going to make you pay liquidated damages and all the other penalties. So the state kind of stepped in and said you're only going to be liable for in a reasonable value. So all of a sudden, the the price can't spike 30% on your final invoice. It has to be reasonable, and you're only liable for what was owed up to that point. No termination fees. And it says right here clearly no penalty for such cancellation. So I think that's good. Puts the power in the association, in the neighbors, which is what you want. If the board votes against the proposed activity, the director or officer or the relative of the director or officer must notify the board in writing of his or her intention not to pursue the proposed activity or to withdraw from office. If the board finds that an officer or director has violated this subsection, the officer or director shall be deemed removed from office, and the vacancy shall be filled according to general law. A director or oh wow. I think we have one more slide after this. How to handle a potential conflict of interest. A director or an officer or a relative of a director or an officer who is a party to or has an interest in an activity that is a possible conflict of interest as described in subsection 1 may attend the meeting at which the activity is considered by the board and is authorized to make a presentation to the board regarding the activity. After the presentation, the director or officer or any relative of the director or officer must leave the meeting during the discussion of and the vote on the activity. A director or an officer who is a party to or has an interest in the activity must recuse himself or herself from the vote. And the attendance of a director or an officer with a possible conflict of interest at the meeting of the board is sufficient to constitute a quorum for the meeting and the vote in his or her absence on the proposed activity. So that's, again, kind of what I was mentioning before about having to remove themselves when they're voting, and then they may come back, after the vote has been placed. And then, but it does not mean they can't attend the meeting. So just because it's on the agenda to, present their company, that does not mean they can't attend the meeting. They could go to the meeting, this person and their relatives. So I also want to hone in on that too. It doesn't just mean it's their relative. So spouse, brother, sister, cousin, whatever it may be, they'd have to leave as well. So they could do the presentation to the membership, but then that person and their relatives have to leave while the vote is taking place and while the further discussion is taking place.
There's a question. Are there any limitations to the association contracting with individual owners for association work?
Is there any limit to an association contracting with a unit owner? So I'm assuming, if I understand it correctly, if let's say they're already contracted with like Joe in unit 101, now they're also going to Sally in unit 304, and now they're going to Sella in unit 502, like that kind of stuff. Like not
Well, I might have read it a little different. I might have read it as a unit owner who's a handyman.
okay,
So
so
if a unit owner is a handyman, can the association hire him to do work?
okay, so he's
So
just go
go
ahead.
ahead.
I was gonna say, so I understand it basically there's an owner there and they're giving him all this work. He's a handyman. I mean,
Right. Best practice would be that he should have a legal company, that he should have insurance.
Yep.
You should not just be hiring an individual owner to do association work that is not properly licensed and insured.
Yeah, that's a big one, especially in condominiums, because we get it. You want to save money when because an electrician is going to charge you $300 to replace this fan. When you can hire a handyman, he's going to charge you $100. Like, I get it. At the same time, like Jamie was mentioning, first and foremost, is this owner licensed and insured? Do they, I mean, in my experience, typically they're not, and if they're not, then automatically they should not be doing it. If they are, they have a legitimate business, and they have the insurance that they're allowed to work in commercial facilities. Because in this case, even though you're dealing with people's homes, like residences, you're dealing with a big building, so a lot of times they kind of deem it as commercial. And you're being employed by the association, but anyway, not a homeowner, but a business. So typically in those situations, they could use him as much as he want, so long as and so long as all those requirements are met, that that they have insurance and their license. And then the other thing is the work he's doing it's something that a handyman can actually do. In condos, at least in my experience, in a lot of these cities, Pompano Beach, Fort Lauderdale, Delray, Hillsborough, a lot of these cities, Fort Lauderdale, if you're doing anything outside of, let's say, painting, or you're just, cosmetic stuff, they're going to want to see a permit. That's putting in a new shower pan, that's, replacing your cabinets. They're going to want to see a permit for that. Sometime when you're replacing the flooring, they're going to want to see a permit for that. A handyman can do it typically, yes, but most handyman can't pull permits. So that's another thing, that's another layer that kind of gets added to the question is, what kind of work is he doing? Because if they're doing work that requires a permit, then again, it's a no from the beginning. But if they just have this guy to go around doing, I don't know, there's a drywall patch, he's patching a drywall, there's a unit that was vacated, but we need to call bulk because the person left it is a mess and now it's bothering neighbors. Like, so we need to go in and throw a bunch of crap away. They can do that kind of stuff. The dumpster's, a mess, we need to clean it up. That kind of stuff, great, no problem. I'm sure it'll be a lot cheaper than hiring somebody else, on the street because they are there. It's a handyman that's on site. But if it's not that and they need a permit, that's when it gets kind of sticky. But then they could use that guy for as much as they want for those little things, and it doesn't matter. Any other questions?
Absolutely, but insured and licensed is the answer to that question, I do believe.
Mm-hmm. Yeah.
When you're done, I have questions that don't really relate to what you've been presenting, so I've been saving those.
Okay, so I'm going to do this last slide, and then maybe
Okay.
we'll get into those. So the last slide is how to handle a potential conflict of interest. A contract entered into between a director or an officer or a relative of a director or an officer and the association, which is not a timeshare condominium association, that has not been properly disclosed as a conflict of interest or potential conflict of interest as required by this section or section 617.0832 is voidable and terminates upon the filing of a written notice terminating the contract with the board of directors, which contains the consent of at least 20% of the voting interest of the association. As used in this section, the term relative means a relative within the third degree of consanguinity by blood or marriage. Now that's defined basically like a third removed from you. So I guess you'd have like, let's say your cousin's cousin. That should be okay. That's third, but cousin's cousin? Maybe not. And that's it. That's the last one.
Okay, then I'm going to move on to some questions that weren't really part of the topic, but others may find them interesting.
It's 12:10.
This is from Jessica. For the Rules and Regulations Committee, for rules and regs, if a committee has been put in place and they suggested rule changes, can the board disregard their suggestions based on the community's need?
Oh yeah. I mean the committee is working as like an extension of the board in some regards, but they are not the board of directors. So they're not the ones who are making the changes on the rules. They're not the ones who are approving any kind of changes to the rules and regulations. And then first and foremost, you can't just change the rules. They have to send out a notice, 14-day notice, typically send out a 14-day notice, and then they have to send what the new rules are going to be. So that's not stuff that the committee would be doing anyway. If the committee presents something to the board and the board disagrees and they say, we don't like it, or, it seems like we have a different opinion, that's perfectly fine. The board has every right to do so.
Is there any regulations regarding residents installing door cameras on the hallways of a condominium building?
Oh, that's such a
That's a hot topic.
that is a hot topic. That is a very hot topic. And again, I'm gonna say that's something for your attorney. What I will say, in my experience, and I just want to make sure everybody heard me say that's something for your attorney. But in my experience, I've seen it. So some associate, because what happens is people want Ring cameras, right? And so they put a Ring camera in front of their door. But a lot of times the way these buildings are designed, you may have another front door right in front of them. So now their neighbor across from them, they're having their privacy breach because their neighbor is essentially recording everybody who's going into their house, and they don't like it. And so there are situations where things like that aren't allowed, but then there are some times when, they have allowed it. There's been situations where, you could have a security camera, but again, people have to have some level of privacy. So if the association has a camera, it can't point down the hall because then you're getting people inside the unit. You can only keep it pointed at like common elements or like certain angles inside the common elements. So that's why we both kind of responded that way. That is such a there are so many variables that go to that answer. So get to your attorney, get to your professionals, your security company. They'll be able to give you the best answer for your building.
Is there any Florida law prohibiting condo associations from establishing an independent TV cable distribution system? I'm not sure what that means.
Yeah, I mean, it sounds like an independent TV distribution system to me, and I'm not an attorney again, so I can't tell you what laws are there or not, but it sounds like I don't know, it sounds like what, you want to make your own cable company? Like, that's what it sounds like.
Right. So again, I think it goes back to that bulk cable agreement.
Yeah.
As long as the agreement is properly reviewed by the association's attorney and that all Florida statutes and the declaration are followed, I wouldn't think that that would be an issue.
Yeah, people have bulk contracts. They're very common. And they'll be like, and not for nothing, a lot of internet companies would love to get some bulk contract clients. So that could be some good, especially if you're a bigger property, a lot of times it's good leverage where you could, let's say for an extra $10 a month, get internet and some kind of basic TV, which you would never be able to get, by yourself by walking into a store. So bulk contracts could be good. They could be good.
Next question. Can the condominium association suspend access to amenities such as the pool, barbecue, gym, bulk internet service for a unit owner or resident who is either in foreclosure or was previously in bankruptcy if the automatic stay is no longer in effect and the unit is more than 90 days delinquent in assessments.
I mean, anybody delinquent, kind of like what I was saying before, anybody, if somebody owes the association money, you can't suspend their access to common elements. Verify with your attorney, you know, the case, because this sounds like there's a lot of other variables involved. I don't know if they're on a payment plan. Sometimes people have them on the payment plan. And if they're on a payment plan, they can still have access to it, or sometimes you don't have access until you know you're completely paid up. So it just kind of depends. But if you are going to suspend somebody's access, it's typically stuff like that. There was a few lists of item things you can't you know suspend, like the like limited common elements such as elevator or their patio, of course, or parking spots or guest
Or
spots.
access into the community.
Yeah, or access to the community. Like you can't like nullify their gate code and now they can't do that. But you know, pool, clubhouse, you know, maybe having a social event, I guess. Yeah, keep them away. Yeah,
I
Peggy.
think it would be hard to turn off a bulk internet service because the bulk provider is not going to turn off one unit, but certainly worth a try. Peggy, you have something to comment on this?
Yeah, I just want to say that if it is, in fact, legal to do it after you checked everything out, that applies to the renters. If there's a renter in that unit, they cannot, or you can keep them from using the pool, any of the clubhouse amenities and so on.
Well, yeah, and if there's renters, I think attorneys actually prefer that sometimes, because you could send a letter to the tenant and say, hey, you got to pay the association because your landlord is short on their dues. And once the landlords get wind of that, they always come running and say, hey, I didn't know you could do that. I'll pay whatever they need to pay because they want that rent check. So there are so many variables, but I hope that answered their question.
Peggy, you're on mute.
Yes. No, I'm finished. Thank you.
Yeah.
Next one. If someone is hired for office work and is dating a board member's son/daughter and renting the board member's unit, is this a conflict of interest since they are not actually related?
Ooh,
Wow.
that's a good one. I mean,
Wow.
they're not married, they're just dating. I mean, makes sense.
Right?
But I mean, I think it couldn't hurt to, like, you don't have to get into the weeds of it at a meeting, but maybe just say, hey, by the way, that's his tenant. And just like just so people know that, you know?
Right. It goes back to that full disclosure.
Yeah.
Was the hiring of this person properly done at a duly called meeting? Was all of the information properly disclosed, and was there a proper vote? So from a conflict of interest, I mean, the board member could recuse themselves
Mhm.
just to stay in a cleaner environment.
Yeah, it may be one of those like best practices kind of thing.
Right.
Because nobody cares who their daughter is dating. You know, if the tenant thing, I can understand that, you know, but at the same time, I think it may be one of those. The Queen has a comment. Yes, Peggy.
I just wanted to comment, going back to the renter thing, is that maintaining the roster of also who are the renters in your community is really important. And the renters also should disclose their emergency contact information, because if they're in a hurricane and the owner's in Massachusetts and something happens to them, you know, and you can't reach the owner, you've got it on record of who the next person or next contact would be for their emergency contact. So the roster is huge.
Mm-hmm.
And then I have just a comment from Marlene. Insurance and permits are a big piece of the contracting process. Our association is 280 units and we had massive damage from Hurricane Milton. We are now dealing with contractors and subcontractors and requiring each to provide a certificate of insurance. That's a great practice. That's a
Yeah,
great thing that should be done.
that is. And depending on how much work needs to get done, you definitely want to make sure they're bonded, so that way they could see, you know, your projects through.
Right, and make sure all the permits are pulled and those are maintained on your website so that, again, going for that full disclosure, if a unit owner wants to see things, that it's all maintained on that website.
Yeah, that the website is, and like I understand, I've had clients who don't want to invest in something they don't have to, and I get that, but it's just it pays for itself in so many ways, having a proper website. And then of course the website's only as good as maintain as it's maintained. So making sure if you need a committee to maintain the website, which I've seen, or if the manager can't do it, or making sure that if the manager's doing it, that they're on a schedule or how often they're updating the website. Because I will say, similar to maintaining a roster of owners, maintaining the website is a project in and of itself as well, because you're always getting bids, you're always getting emails, you're always going to have meeting minutes, agendas, the roster in and of itself, which typically it'll be connected to it, updating financials. A lot of this stuff, a lot of these systems, they're not all like integrated together. Your banking system is doing its thing, and then you have your payment system doing its thing, and then you have GenArc, or you have for people's database, and then you have another system to collect people's monthly dues, and another one for work orders. So you have all these things that are separate, and your website has to be a hub for all of it. So all these different softwares have to somehow feed the association's website, and as you could tell, it quickly adds up. So it couldn't hurt to have a committee who just does the website. And it also depends on how big your property is. I'm talking because I've dealt with properties that are 600 units, several buildings. Like in those kind of properties, it is a lot, especially in those garden styles. Because you have so many different buildings, and every building has a contract, and so it easily becomes a whole lot. But again, just making sure you have the right people maintaining it, it will pay for itself, and that is, again, one of the best practices.
In our prior conversation, we talked about using association members, and we said that they should be licensed and insured. And I think you had made a comment about they should be bonded. Well, David Garrity's comment is, doesn't the cost for the bond, its purchase, fall to the association? To say they are bonded is not that simple. Am I correct? My experience is the board could have a cost of 4% of the contract price.
Yeah. I've mentioned that because she meant the person who asked the question mentioned having a lot of damages from Hurricane Milton. So a lot of those projects when you have hurricane damage, depending on how bad it is, yeah, you definitely wouldn't have somebody bonded. As far as like the cost, the association's always paying for it one way or another, whether they're included or whether they have it as a separate line item. It's up to typically like the engineer or contractor. But it's good depending on the size of the project.
Sharon had put something in the chat, and I will just remind you all, if you wouldn't mind putting it in the Q&A so it gets properly addressed. But Sharon's comment was, are there any laws on insurance? We have a small condominium association that had a considerable amount of damage from Helene and Milton. Nothing was covered. Are we required by law to keep flood and wind insurance?
Yeah, you have to make sure the association is properly maintained.
Well, you need flood if you're in a flood
Yeah,
zone,
properly insured.
right? So your association needs to be properly insured. And one of the sponsors, as Peggy highlighted for our events, is Daniel Baum of COA Solutions. He's an experienced broker. His number was put in the chat for anyone who has needs clarification on their insurance policies. But again, if you've put information in the chat that I have not addressed, please retype it into the Q&A while I continue on the Q&A. Doris says, what's the best practice use of association email? Our president is the only one with access and refuses any other board members access.
Well, I mean, that's kind of interesting because you're a board member, you're also an owner, right? So owners have access to the association's emails. So it's, and then there was also some penalties for people who don't give access to records. And so this may be one of those things where demand letter gets sent out, strongly written letter from the management company, from the members, if the attorney gets involved, get the attorney involved, send attorney opinion if you need attorney opinion. But the email address should at the very least be accessed by the other board members. You know, it shouldn't.
Right, full disclosure, that's what you want, is best practice for any association, right?
Yeah, full disclosure, transparency. It's a glass house. Just keep everything see-through. Everyone be happy.
Can you discuss sunshine law as it relates to the use of email board activities, do's and don'ts?
It sounds like an attorney question to me, to be honest with you.
Well, sunshine law just says that everything should be done in full transparency. Things shouldn't be done behind the scenes. Everything should be brought to a board meeting, to a motion. There shouldn't be business transacted that is not transparent to the community.
Thanks. Yeah, I didn't know how much in the weeds they wanted to get into it, but essentially,
Well, I think just globally,
that's kind of,
I think that's the overarching truth of
yeah.
what sunshine law's intention is.
Yeah, just make it, and even as we gone through, this course together, I mean, there are so many, and this is just, it's really just, the tip of the iceberg, but the prevailing mindset, it seems like from all these statutes, is about transparency and making things available. How to handle conflict of interest, how you're supposed to handle your election, how the meetings have to be posted on the website, posted in the front of the on the front of the association's website conspicuously with notices. So I mean, if you same thing I tell my kids, if you have to keep it a secret, may not be something you should do. So you gotta ask yourself the same thing when it comes to these running these buildings. It's nothing's a secret. Everything's open. There were some occasions where you don't have to share, but very seldom. It's pretty normal to just let everything be viewed by owners.
Right, high level, it would be legal activity, any lawsuits against the association,
Yeah.
or information about payroll of people. Those are really your two high level things that wouldn't be disclosed. Pretty much anything else should be available, especially if it's discussed at a board meeting.
Yeah. Any other questions?
Yes, a condo built in 2004. We have not amended any bylaws since then. How do we update or amend annual update from Florida laws annually? I'm not sure. I guess the simple answer to that is any amendments need to be done through your attorney. And they don't necessarily need to be done annually. It depends on the language that is in your declaration that brings it current to all the changes.
Yeah, you want to run it by your attorney. Because your docs, or looking at at least start with your condo docs, because that'll tell you how you're supposed to amend your docs and how to amend your declaration if you never amended it, which is good. It's good that you have that in your mind that, hey, it was built over 20 years ago. We want to amend it to a more current, to kind of fit current needs. That's a very, pragmatic way of looking at things. So good job. Go down that road, open that can of worms per se, and see where you can make improvements in your condo docs. I think that's great. I think more associations should be doing that. Because it is a challenge. I will say that typically, you have to put the notice together, you got to send out You have to, and that takes the attorneys, because you have to, even the way it's written, it has to be written in a certain way. Then it has to be notified to everybody. Then you have to post it, and you have to be on the website. And you have to have the meeting minutes. So you have to take a vote. So it's a lot, but it's worth it. Definitely worth it.
Well, it's being an association board member and following all the rules and regulations is a lot.
Mm-hmm.
It is a requirement to make sure that everything is kept up to
Exactly.
date.
Yeah, if you want to do it well, it's going to take work. If you
Which is why most associations recommend using a management company,
Yeah.
because board members are volunteers. That's not, yes, they now are required to get all of this education, but there is a lot of work that happens behind the scenes. So getting a management company, i.e. calling Brian, is a great idea, so that you are making sure that everything is kept current.
Yeah, it's a lot, even from this side of the aisle as a manager, and being a volunteer. It's you got to have a good team with you. You really do.
I have another question. Can the board change rental parameters, reducing how many times a homeowner can rent in a year or minimum months to rent?
The boards, there's ways they have to follow it. Typically it may be amendment to their rules. It may be an amendment to their docs. If their docs talk about renting procedures, most of the time it's kind of like a rules. The board has a right to change the rules. So yeah, they can. It's always, but if you feel there's an issue with a rule, a lot of times, again, these are volunteers, so you could volunteer to be on the board. You get input from your other owners if you feel what they're doing is not, in line with what the community is doing. It could be difficult when these sort of things happen, because everybody has their way on which they want to do things, and they'll dig their heels in the sand. So it could be difficult sometimes to see the other person's point of view, when the board may have this thinking, and the owners have this thinking, and now it happens. So maybe there's a way to kind of look in the middle, because yes, again, the board can, they make that rule, if or change the rules on renting and those kind of procedures, assuming that they follow all the other requirements and guidelines that they have to do before they make it official, but they can do it. So how can you have that conversation where, if they are going to change it, they change it in a way that really is in favor to you as the owner and to your neighbors. It's all about having that real good communication. And sometimes, again, this is a shameless plug with a manager. Sometimes you need to have that mediator between the board and the owner, because things just become contentious. Again, you're all neighbors, you all live together, but you all have a shared interest, but things just get personal needlessly, which happens all the time. So you need to have somebody who's a little bit more removed from the situation to offer some guidance to come to that resolution. So it's a lot. I know a lot of these answers I feel like are very long-winded, but as you could tell, when it comes to associations, there are so many variables that come into play, and you are dealing with sunshine law, you're dealing with with other state laws, you're dealing with statutes, you're dealing with attorneys, you're dealing with your condo docs, you're dealing with your rules. It could be a lot, but with the right team, it helps, it makes it a lot easier for you. I'm sure, Jamie, you would agree with it. You've been doing this a lot longer than I have, so you know what it feels like.
I do. 2 questions relating to docs. Is it better to amend the docs or do a complete rewrite? And then can the board amend the docs without owner's input?
I mean, a complete rewrite, I haven't seen that done. You can, I guess, but that's
It would be
very,
costly.
very costly. Your docs are maybe 100 pages a lot of times, and you're gonna have a new attorney rewrite all 100 pages. It's gonna cost you tens of thousands of dollars easily. May not be the best use of your money. It would be better to, no, you can do is review it, and make the recommendations on what needs to be changed, and then go to your attorney and say, hey, this is what we want. And typically amending your docs, you need input from the owners. So how that looks like is you would have I wish I could pull up an amendment. I just had an amendment meeting a few weeks ago, but basically they would send out typically it's 14 days, but they send out at the minimum, but you send out you'll send out the new amendment in addition with the old amendment, and the old amendment would be strike through. So there'd be lines so people could see exactly what's being removed. And then in red wording or conspicuous wording in that same form, they'll also include the new amendment writing. So people could see what's being replaced with what. And that would have to go out to all the membership. Typically, you would need input from, it depends. I've seen the majority plus one. I've seen 70% of the membership, 60% of the membership, whatever it may be. But typically you have to have some kind of input from the ownership of the association before they can amend the docs. It's a lot more difficult to amend the docs than change the rules. And rightly so. You don't want tyrants. But we know that doesn't exist in condos. There's no such thing as condo tyrants. So so for that reason, you have to take it to the membership, typically.
Right. And David has a comment to that. We rewrote our docs from 1978 completely, price tag $9,500, and still collecting proxies for the approval of these docs.
Wow. From the 70s?
Well, the documents were from 1978.
Okay. Yeah, see, that's about right. Almost 10 grand just in rewriting it. But hey, I mean, they made the investment for it. I'm sure they'll reap the benefits in the future, but they're still receiving it. It's tough, man. So many people, everybody lives their own lives and they have their own problems, and now you're asking them to get involved with their association. They thought they could just buy the unit and that would be it. But condo life is buying a condo is a lifestyle. As you can tell, it's a complete lifestyle.
In my experience, having town hall meetings when you need something of, majority unit owner approval is always a great practice. And whether people attend or not, they can be included in Zoom so people could log in wherever they are. And then usually have committees to have people go knock on doors or put notices on garages so that it's something different that they have to pay attention to, that help, we need your signature.
Yeah, I mean all those are just so good. It really is. And it helps. Like people forget that buying a condo, it's more than just your unit. You have a whole business basically to take care of on top of it,
And then the next question, is there any way unit owners would be grandfathered in to the old documents when the docs have been amended following all of the guidelines?
It depends. And
I think that's the right answer. It depends.
Yeah, because
And if the board wanted to allow grandfathering, they might indicate certain items
yeah.
in that to allow those, but in general, it's not a simple yes or no answer.
Yeah, you gotta look at the wording of it, and so it depends.
If a board member is constantly violating rules and regulations, can they be removed from the board? I think we discussed this already.
Yeah, the pitchforks. I think that was
Pitchforks, that it's the other board members that could remove them, and there is a process that the community could remove them.
Yep. So that's what you may want to explore those options.
This one also was addressed previously. If we have a management company website, do we need one of our own?
Yeah, I mean, the management company, yeah, we answer that. They could provide it so long as you have your own, portal and your own. It's password protected, so not just anybody can get access to it. That's perfectly fine. If you want to, you don't have to host the website yourself. That's quite common. You'll go to managementcompany.com/limestone association, and then you go on it that way. So that's very possible. The Queen speaks. We're just top of the hour, just about.
I know, I just wanted to comment on that because I don't think it is allowed. I think you have to have your own independent one for, first of all, the reason that in case you change management companies, and you have to have, you know, autonomous control of your website. So that's
Yeah,
pretty,
yeah, it's definitely
I mean,
recommended.
I'm
But
sorry,
in
you can put a link on yours to go to theirs to make payments and so on, but you have to have a standalone independent website for your condominium. And
Right, but it can be linked to a management company. A management
yes,
company can be doing the website. I had
yes,
just said it is best practice to have a standalone. So if you were to leave a management company, you wouldn't have to start from scratch to recreate the website.
and then making sure that it's password protected. That's a big key as well. It shouldn't just be accessible to like that. Like it shouldn't, like that portion shouldn't just be accessible to everybody. If you have it with the management company, it's password protected. The owners have access to it that way.
also you would never have any issues of retrieving any records in your own files on your own website from the management company. And
So
that
can
does
you?
happen.
Yes, highly recommended. To keep your own though.
I don't have any other questions.
All right, kids. So we're a little bit early. I guess I'll turn the meeting back over to Miss Peggy.
All righty. Well, first of all, I want to say congratulations to all the board members that are on, and thank you for choosing our webinar to get your certification. Brian, you did an excellent job as usual. Jamie, thank you for the support and all you did, preparation and so on. And I just want to let you all know that we as in Brian and I, and hopefully Jamie, are going to continue to have these condominium board certification classes throughout the rest of the year, probably bi-monthly, Brian, something we discussed a while back. But for sure to help anyone and everyone. So the other thing I'd just like to ask, if anyone out there could please send me a private email asking or telling me what other topics you might be interested in, because what I do is actually provide educational webinars to board members and CAMs as a business. You know, just to put in the back of my mind, I can be searching for even the upcoming meetings up in the later stage of the year for the board members who are out of town. I want to congratulate everyone again and say thank you to the sponsors. And I also want to mention a few upcoming webinars. Starting with next Tuesday, Matt Cusley, who was on today. You will be getting a flyer about this, and he is going to be speaking on budgeting and reserves, and his company name is Reserve Advisors. So he mentioned he was in the business at that company for 25 years. I'm not sure how old the company is, but 25 years of experience. He is an icon, and he will be 2 hours on this subject. So hopefully you can make that. Also, we have a roofing class coming up on June 3rd by Best Roofing. It's called Roofing Masterclass. June 19th is Painting by Benjamin Moore. We have Unlimited Restoration coming in, speaking Towering Above Trouble for restoration issues. Back into July, I am starting a Spanish speaking class with Karen's Engineering, July 10th. July 17th, we have a different reserve company, Association Reserves, speaking on 1 hour of budgeting and Sears. So there's a lot of things coming up. You know, I'm already booking out into September. So please, I hope you enjoy these webinars. I hope you get a lot out of them, and I wish you all the best. One last thing to mention, if you're in the South Florida area or you want to travel to the South Florida area, on June 12th, I've started the Palm Beach County President's Club. It's going to be a meeting on June 12th. It's an in-person meeting from 10 a.m. to 2 p.m. And we're going to have hurricane awareness as the topic. And the keynote speaker is the Palm Beach County Director of Emergency Management. So also, just please allow 2 to 3 weeks for Brian to review all of the information on the Datalytics about your time on the call to get you a certification. And if you have any other questions about that, please reach out to him directly. I want to say have a safe holiday in closing, and hopefully we'll see you soon. Thank you.
Bye, everybody.
Hey, thanks, everyone.
Mhm.